Yes.
May it please your lordships. Lordships, I beg to mention a freshly filed appeal, my lord, statutory appeal, offence of 302, was filed on 9th of January, my lord. Matter may be listed as per lordship's convenience next week, any date, my lord, for admission.
I think you take up the matter with the registry. They'll get it listed.
My lord.
Will not
my
give a
lord.
date. Okay,
My lord.
take it up.
My lord, there's another appeal. This is with regard to an IA, my lord. The incarceration has been 1 year back. New medical grounds, my lord, in that pending appeal.
Same
One
thing,
IA has
same
been filed. That next week, my lord. Any
Same
date?
thing also. You take it up with the registry. Okay.
Then subsequently.
Hmm.
Obliged.
May I please, my lord, I beg to mention item number 7, my lord. Lordship may kindly adjourn the matter for today, my lord.
For today,
For today, my lord.
why do you want adjournment?
The conducting council is facing some difficulties, my lord. That's
Item number?
7, my lord.
Just
Hmm.
item number 7 and item number 8. They are connected matters, lordship, the same order are being challenged here. So both of them may be together, lordship.
7 and 8. But
7 and
8 is for orders.
But the pleadings are over, lordship.
Is the bail order, challenges of the bail order or?
It's the
Bail.
rejection of the,
Rejection of bail order, my lord.
it's the same order, lordship.
If possible, my lord, on matter may be listed on 20th of February, my lord.
7 and 8, isn't it? They're
7 and 8,
together.
my lord.
They should be together.
They should,
Okay. Anyway, who's the conducting counsel? Who has
And-
difficulty?
NJ Datta, my lord,
NJ Datta.
in item number 7, my lord.
Okay. So you will do one thing. We'll pass the order as and when the matter is called up.
Yes, my lord.
Okay.
If possible, on 20, matter may be listed.
Date we will get as per the convenience of the court.
Obliged, my lord.
Sir Lordship, I beg to mention item number 11 and 20 of the daily list for adjournment, Lordship. There is some difficulty on part of the conduct.
11 is not listed.
Has been deleted.
Deleted.
And 20.
11 is deleted. So you need not mention. 20, what do you want?
Adjournment
You are for the
petition. Appellant.
appellant. Why do you want adjournment?
There is some difficulty on part of the conduct.
Who is the conducting counsel?
Good.
PP?
No.
Okay. Mr. P. Katoki, learned counsel for the appellant, is said to have some personal difficulty to conduct the case today. And on a mention made on his behalf, and not objected to by the other side, matter stands adjourned. We'll state again after 2 weeks. All right.
Daily list item numbers 1 to 6 for admission.
1 to 6. Yes, what are these?
Peter,
matters?
the conducting council is having some personal difficulty. Item may be urgent.
Who is the conducting counsel?
Amit Goel.
Sorry?
Amit Goel.
Amit Goel. What kind of personal difficulty?
Health issue.
Health issue. Who's for the other side? Something to do with VAT.
Revision lies before. Revision lies before this court. 81 is also a revisional power of the revenue authority. Commissioner also has a revisional power. So yeah, I don't know whether there is a second revision. Yeah, look.
Some Value Added Tax Act 2003. See, brother, if you see the order passed by this court, it says appeal as before the High Court within 60 days. The revision can be done. Order, you have a copy of this order? 6/1/25. Orders this court. You can have a look at this. Something has been mentioned there. Impugn order is passed by the revision court under section 82. This revision division under 82 of the essence of
That's okay.
Commissioner, Joint Commissioner of Taxes. Mm. 82 is revision. 82 is revision to the commissioner, 81 is to the High Court. So it lies here also. This is the head. 82 power is other than the appellate authority. 81 High Court power is against the appellate authority. So I think it's an order, brother. When do you want it?
After 3 weeks.
3 weeks. Who appears for the opposite party?
B.
B. Gogoi. B. Gogoi is a standing counsel.
Yeah.
Asset taxation.
Hmm. Your good name, please?
P. Saraugi.
P.
Saraugi.
Saraugi. Now, have you informed the other
Yeah.
side?
Yeah.
Mr. P. Saraugi, learned counsel appearing on behalf of Mr. Amit Goel, submits that the conducting counsel, Mr. Amit Goel, has some personal difficulties to conduct case today, and therefore prays for the adjournment for 3 weeks. Mr. P. submits that he has taken the consent of the learned counsel for the other side. In view of above, the matter stands adjourned. To be listed again. Give a date. 3 weeks. On 12/3.
I
1 to 6. Same order.
7,
Give item 8 also.
7 and 8.
Now,
Your Lordship, as far as item number 7 is concerned, my friend is saying that my colleague in item number 7 has taken an adjournment. But as far as item number 8 is concerned, my lord, we both agreed that today we'll be hearing it.
we'll be doing the same exercise twice, Lordship.
The problem is what is that
Hmm.
this appeal has been filed almost a year back, my lord, 7th August 2025. I've been behind the bars from 2024.
Item 7 is against the rejection of bail. right?
Yes.
And item 8 is
Rejection of bill.
Same.
Same.
Same NI case.
Same NIA case. In fact, what happened, your lordship, is that.
but party is different.
Pardon, my lord?
Party is different, isn't it?
It is different. The argument which was canvassed in the special court NIA, which resulted in the rejection of my bail, our bail application, was that with respect to the grounds of arrest. The learned trial court did not discuss that. The learned trial court did not argue, look into that aspect. Learned trial court said that since the gravity of offense is there, we are not going to grant the bail. That is the main issue, your lordship. Now, my lord, I would like to take certain chronological of facts.
For Manipur,
Manipur, my lord.
conducted here.
Yes, that has been transferred from the Supreme Court. I have annexed the order. But these are a compilation of the judgments. In fact, I must say, the arrest which has been made is that the NIA is trying to defend the arrest of me by the Manipur police. Because I was not being arrested by the NIA.
Okay, Mr. Borgohain, see, thing is that since the matter relates to the same issue and one party in item 7 wants some adjournment. And the opposite party is the same.
It's the same.
Mr. R.K.D. Chaudhary will be inconvenienced.
Because if if
Inconvenience.
this matter goes in my favor, or if this goes in any other favor, that will be parity will apply to both other matter also.
That of course would is there, but at the same time, at the risk of the counsel for the other case, there will not be proper.
My lord, problem. Date the trial of an visit.
I don't know.
No, that's the reason, nah. That also in Manipur.
I don't know.
That is the problem. And we all agreed on 10. I was being taken up.
Sir, here.
No, transnational conspiracy is in Delhi. And I was being told today morning only, just now, while having a cup of coffee. My lord, in fact, the matter came on the last occasion. Both the parties agreed that let us be pleadings be completed. Let us argue on 10. So as in light of that, the matters were been fixed here.
No, but it's fixed in the orders column.
Well, it can be.
That's why.
Pleadings perhaps were not on record.
It's on, it's admitted, the second one is admitted.
Yes, yes,
So
yes.
we can admit this one also
Yes.
and then place it together with orders.
My lord, in that case, I will request your lordship that can it be taken up?
Subject to implement.
Can it be taken up, my lord, in this month itself? Like, huh?
25,
25. Can it be taken up on like 39?
39.
2nd of March, my lord?
No, not on 2nd of March. No. It can be on
Because the charge hearing is also pending, my lord, in that matter.
4th of March.
Because your lordship will kindly see the order passed by the Honorable Apex Court at page number 59. My lord is there? Page 59.
Yes.
This is the order in which all the 7 cases have been transferred to the special court NIA Gauhati. The detail order and page 62 is the proceedings record.
Mm.
Now, my lord will kindly come to page 74. Page 74. Page 74, para 6.
Page 74.
Page 74, para 6.
Page 74.
Page 74 is the
Order of NIA.
affidavit in opposition filed by the NIA. Kindly see what they have stated.
Item 8. Looking at item 7, I think.
Page 74, para 6.
Para was replying.
My lord, the Manipur police arrested the above accused person from after completing the required formalities and orally informed grounds of arrest. They have admitted that there is no written grounds of arrest. The affidavit in opposition. So our limited issue is that whether the grounds of arrest has been complied as per the law or not. Because they start from Pankaj Bansal right up to the Mihir Shah. And remand application cannot justify, my lord. That is the law now. So it's a small issue, my lord.
All right, let's fix a date. So item 7 is in the admission column.
In fact, both the matters pleadings were
one-
completed, my
The
lord.
other one is in the orders column.
Yes, my lord.
Now, as far as your case is concerned, Mr. Borogohan,
My lord.
why it's listed in the orders column? This
My lord, normally it should have come together, 7 and 8 together. Because in criminal appeal, particularly with NIA bail matters, it can be disposed of in admission stage also, order stage also.
So let both come in the admission column then.
My lord.
A notice was issued on 31/10/25.
My lord.
Thereafter, the opposite party have appeared. They have filed affidavit in opposition also.
My lord, in that case, let it be recorded in the order sheet. I have given a compilation of the judgments. Because, my lord, I have given a copy to my friend also.
Please write down. A prayer for adjournment has been made on behalf of Mr. N.J. Datta, learned conducting counsel in criminal appeal number 433 of 2025 on grounds of personal difficulty. Mr. R.K.D. Chaudhary, learned standing counsel NIA,
Deputy SG.
Deputy SGI, has no objection to the prayer, but submits that the matter may be clubbed together with criminal appeal number 345 of 2025, since the issue related and the case and issue related are one and the same. Stop Mr. S. Burogohain, learned counsel, appears for the appellant in criminal appeal number 345 of 2025 and submits that issue involved is a limited issue and the matter may be heard. Stop. He also submits that he has also submitted a compilation of judgment and citations on behalf of the appellant. Next para, considering the above submissions, we deem it proper that the matter be heard together. And accordingly, as agreed to by the parties, let the matter be listed on
12th of March, my lord, Thursday it is. 12th of March, pardon again. 12th of March.
12th of March in the admission column for admission hearing.
My lord. Records have already been received, my lord. Records have been.
Because of the council.
Item 9.
Oblige, your lordship.
May I please? So we will, the appellant prepared this appeal against the order and judgment dated 22/7/2025 case. But in the appellant was convicted and sentenced to suffer rigorous imprisonment of 10 years and to fine of rupees 10,000 under section 4 subsection 1 of PROCEEDINGS Act. And further convicted and sentenced the appellant to impose fine of rupees 500 under section 3. Earlier upon this honorable court issue notice and we have already taken step upon the respondent number 2. Registry as well as I have also sent soft copy to the PP office, lordship.
Yes, so has notice been served?
So Chef, there's office note saying that the report is ready, the supplementary file, I didn't get it, Lordship, maybe.
Which supplementary file?
Live to cut it, it's not on record, objection of us is not on record.
Where is the IA?
This is a connected, lordship.
IA 1240.
This is from.
This is what? That's the same thing. We'll give a date for the appeal. List the matter again on, so and so give a date.
26-2.
Oh, can it be before that, Miss? 24-2, okay,
24,
2026.
6.
Then in the IA also you write, as prayed for by the learned additional PP, further 2 weeks time is granted for filing objection. Please the matter on 24-2026.
Much obliged.
Item 10.
May I please, your lordship?
Yes,
Lordship, we have taken steps, but steps is not completed, lordship.
steps on.
Lordship, kindly allow me to take steps by justice service, lordship.
You are the applicant.
Yes, lordship.
There's a delay of 74 days. You want to take steps by Dusty?
Yes, lordship.
Do you know the address?
Yes, lordship.
It is seen that notice has not been served upon the sole respondent. What's up? Your good name?
A Huda,
A. Huda.
A Huda, mine.
Mr. A. Huda, learned counsel appearing for the applicant, submits that he may be permitted to serve notice upon the respondent by way of dasti. Prayers allowed. So the applicant shall serve notice by way of dasti through the registry of this court within 10 days from today. 10 days? And thereafter, file an affidavit to show proof of service. List the matter again on 10 March.
Apply.
For hearing item 12,
Wait. So appeal against a judgment and order dated, my lord. 14/2/2020. Conviction is life for and fine of 10,000 in default, my lord, for 6 months under 302, my lord. Prosecution's whole cases depend upon the reliance on oral line declaration, my lord.
Dying declaration.
Oral, in oral.
Okay.
Initially, that plea of juvenility was raised, my lord, but after that medical report and all this, my lord, last occasion, it was revealed that accused was 21-year age, my lord. So that plea has gone. Initially, I took the stand, my lord. Yes, there is a mention in the investigating officer's report regarding the age of the accused, my lord. So that issue is already been settled. Now this hearing would be on merit.
On merit.
Merit.
This is for the other side. Ms. Bhuya, you are there. You ready? You're ready?
Yes.
All right. Where's the FIR?
FIR is page 4, my lord, paper.
Please read.
Humble submission is that around 1 AM today, that is the 18/9/16, while my brother Vikas Purmi was enjoying Manasa Puja celebration at the line number 9 of Honwal Tea Estate, all on a sudden Dinesh Rao, son of late Oren Rao, resident of same line, previously injured my brother by stabbing him in the stomach with a sharp knife. Presently, he is undergoing treatment at Gauhati Medical College.
1 AM today. Today, that means early in the morning.
Early in the morning. It was late night and early morning, in between that. Thereafter, my lord, charge was framed on page 6, my lord, 302. Thereafter, page 6A, my lord, on 26/12/2016, sent for trial to the session judge, Gauhati.
Date of occurrence is 1 AM of 18/9/2016.
As reported in FIR.
Same day FIR was lodged.
Not.
Charge framed under 302. Then how many prosecution witnesses?
Here are, my lord, 7 prosecution witnesses, including the doctor as well as the police officer, investigating officer.
And for the defense,
Defense none, my lord.
court witness?
No.
No. So conviction is on the basis of the evidence of the 7 prosecution witnesses.
Yes, yes.
PW1,
PW1 is page 11, my lord. Sorry, page 9, page 7, my lord. Informant as well as elder sister of the deceased man.
the victim succumbed to his injury
Yes,
on the same day,
Belly, ma'am.
on the same day,
Same.
in the hospital or on the spot.
No, initially he was stabbed at during the Puja celebration, my lord. Then in a injured condition, he came to home. Thereafter, he was taken to the medical, my lord. After 3 days of treatment, he succumbed to death, my lord.
On which date? Date?
21/9/2016.
9 16. And Lordship may kindly see postmortem report 9/6 date, my lord.
Hmm.
Examination is done on 21/9, my lord.
Postmortem.
Yes, ma'am. PM was done 21/9/16, my lord. That is page 68, my lord. Of
And
the
time
paper.
till state is
Invest
24 hours.
Within 24 hours.
12 to 24 hours range. They just give an
That's
opinion.
okay.
Yes.
Okay. Okay, come to PW1, 7, page 7.
Page 7. I am the informant in this case. I know the accused. He is a resident of the same tea garden. The occurrence took place about 1 year ago. On the day of occurrence, there was Manasa Puja celebration in our garden. Because Kurmi had gone to enjoy Puja festivals. At that time, I was at home. My brother then came home running with injuries in his abdomen and told me that the accused had stabbed him with a knife. My brother Ajoy took Vikas to the hospital. After undergoing treatment for 3 days at hospital, my brother died there. In a connection with this occurrence, I lodged an ajahar with the police station. I put my thumb impression in the ajahar, and the ajahar was written as per my versions. Fraud. I did not mention in the ajahar that I heard from my brother because that accused had stabbed him with a knife. It is not a fact that I have falsely stated about because telling me that the accused had stabbed him with a knife. My brother was first taken to the Tea Garden Hospital. On the following day, he was taken to the Jorhat Hospital. It was about 200 feet away from my house to that of the place of where the Manasa Puja celebration was held. Next witness is PW2, my lord, page 9.
Just a minute.
Fine.
His FIR was written in English
Yes.
or vernacular.
Because in our person, no vernacular is available in paper book, my lord. It is supposed to be written in English by the officer concerned. Because she said that she has given thumb impression, so herself it cannot be written.
The original is in English.
Written as per the version of the informant, signed Mufti Jamal Ahmed.
In English or in vernacular?
Probably, oh. Lordship, may I check?
Please check. Because page 4 does not say translated copy,
Yes,
just a typed copy.
yes.
Type code.
Yes, madam, you may proceed meanwhile. The other witness.
Lordship, it's in vernacular.
Vernacular. Then who has translated it?
Maybe they translate this one.
So while preparing the paper book,
Yes, maybe
it
they
was
have done.
translated.
Yes,
Then they should write translated
Yes.
copy, isn't it?
yes, ma'am.
You just examine the vernacular what?
Yes, I'll read it out. My learned friend will understand. I'm so sorry.
Yes, we are your friend also.
Yeah.
We are not your enemy.
Lordship will understand the particular portion. May I read it slowly? Lordship, may I read it slowly?
Sure.
প্ৰতি মাননীয় ভাৰপ্ৰাপ্ত আৰক্ষী বিষয়া মৰিয়নি আৰক্ষী থানা, that is to the officer in charge মৰিয়নি police station, বিষয় এজাহাৰ, subject এজাহাৰ, মহোদয় বিনীত সন্মান সহকাৰে আপোনাক জনাও যে আজি ইংৰাজী 18/9/16 হয়নে তাৰিখৰ মাজনিশা প্ৰায় 1টামান বজাত সোণোৱাল চাহ বাগিচা 1 নম্বৰ লাইনৰ হৈ থকা মনসা পূজা চাই থকা অৱস্থাত মোৰ ভাই বিকাশ কুৰ্মীক একে লাইনৰ মৃত হৰেন্দ্ৰৰ পুত্ৰ দীনেশ ৰাৱে হঠাৎ এখন চোকা চুৰিৰে পেটত খুচি গুৰুতৰ জখম কৰে। বৰ্তমান ভাই যোৰহাট চিকিৎসা মহাবিদ্যালয়ত চিকিৎসাধীন হৈ আছে, গতিকে মহোদয়ক বিহিত ব্যৱস্থা কৰাৰ বাবে প্ৰাৰ্থনা জনালো। It's written as such, my lord. On 18 and 16, at about
Translation.
1 a.m. Lordship, it's correct.
Translation seems to be okay.
Line number 9.
Yes, PW2.
PW2, my lord, at page 9, my lord. The informant is my elder sister. I know
This is again sister of the deceased.
his brother, my
Or brother.
Brother.
Brother of the deceased and brother of the informant also.
and also.
Okay. Please read.
Lordship. The informant is my elder sister. I know the accused. I also know injured Vikas Gurmi. About 1 year ago, Manasa Puja celebration was held in line number 9 of our garden. I had gone to see Manasa Puja celebration. I don't know whether Vikas had gone to enjoy Manasa Puja celebration or not. While I was there at the place where puja was organized, Arjun came and informed me that someone had stabbed Vikas with a knife. On receipt of the information, I went to Vikas's house. Reaching Vikas's house, I saw injuries in Vikas's stomach and that he was vomiting. Vikas told me that the accused had stabbed him in the belly with a knife. After that, Vikas's mother, elder brother, and I took Vikas to the hospital in the tea garden, and later we took him to Jorhat Civil Hospital for better treatment. Vikas died at Jorhat Civil Hospital. In cross, I cannot say as to how many people were there in the place where puja celebration took place. I did not state before police that after coming to Vikas's house, I come to know from him that accused had stabbed him with a knife. It is not a fact that I have falsely stated that Vikas had told him that the accused had stabbed him.
Who is Arjun? Is he also a witness?
No. Prosecution did not examine him.
Okay.
So far as this person is concerned, my lord, he had not deposed anything in 161, my lord, regarding he has come to know from Vikas, my lord, about the accused had stabbed him in his knife, my lord. Otherwise, in chief, it is told, Vikas told that the deceased told him that he had stabbed him belly in a knife, my lord, with a knife. And the PW, my lord, 7, the police officer has also stated in his evidence, my lord, regarding his non-submission under 161. Next one is page 11, PW3, my lord.
Yes.
I know the informant as well as accused. He is supposed to be an independent witness, my lord, not related to the deceased or accused. I also knew Vikas Kurmi. The occurrence took place about 1 year ago. Manasa Puja celebration was held in the tri-section of line number 9. At the time, I was at home. The time was 11 p.m. and I was sleeping then. Hearing the screamers of my mother and others, I woke up and saw Vikas with stabbing injury caused with a knife. On being asked, he replied that Dinesh had stabbed him. He took Vikas to the Garden Hospital, but as the injuries were grievous nature, he was not admitted there, so we took him to Jorhat Civil Hospital. My brother died at Jorhat Civil Hospital because did not tell us as to why he was stabbed. Thereafter, my elder sister lodged an ejahat with the police station. Lordship, so far as timing is concerned, in cross, my lord, it is not a fact that I did not state before police that on the day of occurrence, I was sleeping at home, that hearing halla when I woke up, it was stabbing injury in Vikas's belly. I saw stabbing injury in Vikas's belly, and that on being asked, Vikas replied that Dinesh had stabbed him. It is not a fact that Dinesh did not kill my brother. So far as
So independent witness you said, but he seems to be
brother, my lord,
his brother.
brother.
Father's name is Subhash Kurmi.
Subhas Kurmi, yes, it is related to PW1, my lord.
PW1's father was Subhash Kurmi.
The same, my lord.
And why fathers of PW2 is Bharat Kurmi?
Lordship, it is not stated in relationship. Though it is mentioned as elder sister. Informant happens to be mentioned
Their
as
cousins or their
might be, my lord.
Subhash Kurmi, Bharat Kurmi, same surname. Anyway,
Here, my lord, in his evidence, that it is slightly different in timing, my lord. While Ajahar, it is written as incident took place at 1 a.m., my lord. Here, he reports that in 11 p.m., at the time of 11 p.m., when he was sleeping, and after hearing halla and all this thing, he came out. Thereafter, he had seen the accused victim, my lord, and he told that about the incident, my lord.
Lordship, in the charge sheet also, the father of PW1, Rumita Kurmi, is shown as Horen Kurmi, but here Subhash Kurmi.
First, names are
Something is wrong
slightly
somewhere, I
different.
guess. In the charge sheet of the
Spring for a minute.
okay. So 1 a.m. and 11 p.m.
11 p.m. It might be after 11 because he stated that he was sleeping at 11 p.m. Thereafter, the victim came with injury, my lord.
These depositions are also recorded in English or again in vernacular.
Should not be particular because generally what happens, my lord, when original person, then the signature is there, but I'll check it.
Please check
Signature-
it.
Yes,
Please
PW
check,
23.
because you see, when you
Yeah.
translate it,
yes.
then
Meaning changes, my lord.
meaning
Sometimes.
changes. So if you translate literally,
Yes.
meaning is different. But what it wants to say, what they mean to say would be different. And translation of literal translation again varies a bit.
The tree.
So we have to be careful on that.
Particular, my lord.
Handwritten. Handwritten.
Henry.
Thanks.
PW, six is, yes.
So regarding PW3,
Yes, no, it's in Assamese.
that 11, the time was 11 PM.
Yes, yes, Rati 11 মান বজাত মই শুই আছিলো. As regards sleeping part, he is saying so. মাজতে নেকি? চিঞৰ বাখৰ কৰাত,
Hearing-
মাহঁতে চিঞৰ বাখৰ
চিঞৰ-
কৰাত সাৰ পাই আৰু তেতিয়া বিকাশক ঘৰৰ পেটত চুৰি মৰা অৱস্থাত আৰু কি হয়? সোধাত কয় যে দিনেশে চুৰি মৰা বুলি কয়। অৱস্থাত আৰু সোধাত
Yes,
Lordship, I have got judgment student effect. 1 hour, 2 hours, as regards the version given by villagers, it is admissible, my lord. There may be variation of 45 minutes, 1 hour to 2 hours, your lordship. So 11 village people, my lord, and
probably he went to sleep around 11 o'clock
my lord,
and thereafter he woke up.
my lord.
It's not that he woke up exactly at 11 AM and heard screaming and
Yes, yes,
the incident happened exactly at 11.
yes.
So that variation can be there. Okay, please carry on with the evidence of the PW4. 3 we have read, isn't it?
Lordship.
3 you have read. And
Married for money.
see this number 3,
Mike.
Kamal Kurmi.
Yes, ma'am.
This will be he or she. Kamal Kurmi.
I think he might.
He. From the name, can you distinguish whether it's a lady or a gent? Kamal.
Generally in Assam, it is
Common, my lord.
but in this one, North India, sometimes the lady also writes like that. Common. North is so
Because it is, father's name is written Subhas Kurmi, but it is not written as son as or daughter as.
Correct. It doesn't say son of.
No, my lord. None of the evidence is written like, everywhere it is father's name.
So anyway, he is the sibling of the deceased person, isn't it?
We go by the father's name, he happens to be the brother of PW1. my lord.
PW1, correct.
Their father's name resembles.
Yes, please carry on. PW4.
PW at page 13. I know the informant as well as accused because Kurmi was my nephew. The occurrence took place.
He is uncle.
Uncle.
Mm. Yes.
But his surname supposed to be different, but it's Pulli and it is Pulli. I know the informant as well as accused because Pumi was my nephew. The occurrence took place about 1 year ago on the day of Visakarma Puja. It ought to have been Manasa Puja. But on that day, I was at my home. On the following day, Chotu Kurmi informed me that the accused had stabbed Vikas with a knife and that later he died. On receipt of the information, I went to the hospital and saw Vikas's dead body. In cross, I did not see the occurrence. Chotu did not tell me that accused had stabbed Vikas with a knife. It is not a fact that I have falsely stated about Chotu telling me that accused had stabbed Vikas with a knife. So it's a clear contradiction, my lord. In chief, he said that he was informed by Chotu Kurmi. In cross, he said that he did not tell. Maybe hearsay, my lord. And in fact, Chotu Kurmi is not also examined, my lord. He is not a witness.
Hmm. In chief, he says that Chutu Kurmi informed me the accused had stabbed Vikas.
Yes,
In cross, he says that Chutu did not tell me.
did not tell. So it's a clear contradiction.
So it's back to square one. Huh?
And in fact, my lord,
Yes.
the impugned judgment, his version is not relied also.
Chutu is not there, isn't it? In the
No,
amongst the
he doesn't depose anything.
his
not
not
a
name is
witness.
not referred anywhere.
No.
Okay.
And he is not a witness also, my lord. Prosecution did not examine him.
Okay, next PW5.
PW5. I know the informant, she is my daughter.
This is the mother.
He is the mother, my. She is the mother. I did not know the accused because Kurmi was my son. The accused house is one line apart from that of ours. On that day of occurrence, there was Manasa Puja celebration in our garden. On that day, Vikas went to enjoy Puja festivals. Around 2 a.m., my son came home with injuries in his belly, and those injuries were wrapped with a gamuta, a thin towel. After opening the door, when I asked him, he replied that accused Dinesh Rawat had stabbed him with a knife. Then we immediately got him admitted at Gauhati Civil Hospital. At first, we got him admitted at Moriani Tea Garden Hospital, and then we gave the information at the police station. After undergoing treatment for 3 days at Gauhati Civil Hospital, my son died there. My son told me that Dinesh stabbed him on the road near the place where the Puja celebration was going on. Here also, my lord, discrepancy arose regarding the time. The informant says it was 1 a.m. and now when he came back, that mother says that it's 2 a.m., my lord. In cross, I did not witness the incident. I did not know if my son used to go to Dinesh's house to watch television. It is not a fact that I did not state before police that my son came home with gamusa, a thin towel wrapped on the belly, and that Dinesh Rao had stabbed him in the belly with a knife. It is not a fact that I have adduced false evidence for the sake of my son.
We'll call you. Yes. That is the mother. Next is PW6.
PW6, my lord. That is
Who is
the
he?
Doctor,
PW6.
examining doctor.
Doctor. Who examined the deceased?
Yes.
Yes. He has conducted the postmortem.
Yeah. Autopsy.
Okay. Before he died, he had gone to the hospital, isn't it?
Yes.
The examination was not done in the hospital.
That part, no evidence has been laid, my lord.
Straight away, the PME doctor.
PM doctor has examined. And I would like to point out one thing, my lord, though, that deceased told his sister as well as mother regarding the stepping part by the accused, my lord. Neither of that witnesses said regarding the fitness of victim, my lord. Where in oral dying declaration, usually it can be accepted, my lord. And sometimes without corroboration or also if that facts leads to that occurrence, my lord, undoubtedly. But so far as fitness is concerned, nobody has stated anything about his mental fitness to speak out in such a pinpointed manner, my lord. All along in whole the evidences, my lord, on this one point, my lord, missing.
For testimony of one or two witnesses, he died after 3 days in hospital.
Lordship. After during that after happening of occurrence, my lords, there are 2-3 days left in his under the treatment, my lord. So it's a quite long time to have the declaration maybe in a written form or in a proper manner, my lord. Though it is certificate is not always necessary, my lord, regarding fitness.
Sure.
But so far as his fitness is concerned, nobody has questioned regarding, neither the prosecution has projected in a manner that he is a fit condition to depose in such make a declaration, oral declaration to his relatives, my lord. Merely interested witness, because of interested witness, they cannot deny, my lord. But so far as his fitness is concerned, nobody has stated, my lord. Our prosecution is wholly relying on PW1, this PW, my lord, 5, as well as 7 and 6, my lord. 6 and 7, my lord. 6 happened to be the doctor, 7 happened to be the investigating officer, my lord.
Yes.
6, my lord, it started plus 17 and 18, my lord. Lordship may straightly come away to the injury part, my lord, that is page 18.
Yes.
Own's position and character, my lord. Here the description is there, my lord, how deep that wound is and that the stitches, my lord. Stitch owns at size 2 cm is present over the left side of the abdomen, 3 cm below the umbilicus and 11 cm lateral to the midline. On opening the stitches, the wound is buttonhole shaped with regular margins. On reflection of the layers of abdomen, the wound is found to be cavity deep, perforating the large intestine, step wound. The back of the wound, the skin, soft tissues, muscles, and peritoneum are priced, entering the peritoneal cavity and perforating the large intestine direction, front to back, left to right, and almost horizontal. So by this injury, my lord, it is seen that it ought to have been by a sharp weapon, my lord. It's a buttonhole, and in 19, page 19, opinion is there, my lord.
So it says from the back of the wound and the skin, soft tissues, muscles, and peritoneum are pierced,
Yes, my lord.
entering the peritoneal cavity and perforating
My-
the large intestine direction, front to back.
Stabbing part is good.
left to right and almost horizontal.
horizon.
Mm.
In opinion.
It's
it
a
is
stab
stated-
wound.
Next one, page 19, opinion is there, my lord. Bottom. As to the cause of death, death was due to shock and hemorrhage following the injuries sustained as described. Injury is antemortem and caused by sharp pointed weapon and homicidal in nature. Approximately time seen death 12 to 24 hours. And doctor has that postmortem was exhibited as exhibit 1, my report, my
Page number,
4 PM report is, my lord, at
exhibit 1 is at page number.
page 50 of the paper book. Page 51.2, related to the description of own mining. Just we have read now. And opinion is placed at page 55, my top.
So in all 6,
Now 7, my lord,
Witnesses.
investigating officer, page
7.
21,
where is he?
page 21, my paper.
Okay.
May I read?
Yes.
On 18/9/2026 at 2 AM, I was posted at Morioni Police Station as a second officer, and on that day, Ajoy Kurmi and Kamal Kurmi came to the police station and informed us that accused Dinesh Rao caused stab injury on Vikas Kurmi while he was witnessing Manasa Puja. After getting the said information, the officer in charge of Morioni PS made GD entry white number 411 dated 18/9/16 and instructed me to visit the place of occurrence. After getting the information, I went to Honwal State Tea Garden Hospital. I met the injured on my way to hospital and came to know that he was referred to GMCH for better treatment. I took the injured person in my official vehicle to GMCH, and there, while I inquired, he deposed that accused Dinesh Rao caused stab injury to him. Thereafter, after admitting the injured in the hospital, I returned back to police station and thereafter went to tea garden in search of the accused. I could not find the accused in his residence, and after inquiry from his mother, I came to know that he went to see Manasa Puja. Although I searched the residence of the accused, I could not recover any blood-stained weapon. In the morning time, the complainant lodged Ejahar before the police station, and officer in charge of Morioni PS registered a case and entrusted me into the investigation. Exhibit 2 is the Ejahar and Exhibit 2.1 is the signature of then officer in charge of Morioni PS, Jugal Kishore Kolita, which I know. After getting the charge of investigation, I again went to the place of occurrence and drew sketch map of the same. Exhibit 3 is the sketch map and Exhibit 3.1 is my signature. I recorded statement of witnesses of place of occurrence and on 18/9/16 arrested the accused and took him to the police station where his statement was recorded. The family member of the accused produced one birth certificate to me, and after consulting to the officer in charge, Moriani PS, I gave the accused to the Jimma of his mother. On 29/16, I went to JMCH to meet the injured person, and there I came to know from the family member of the injured person that he was already expired. I saw the dead body of the deceased in the hospital. Thereafter, inquest was done on the body of the deceased and later on postmortem was conducted by the medical officer. Later on, I made a prayer before court for AD of Section 302 of IPC as the victim already expired, and accordingly Section 302 of IPC is added in the instant case. Thereafter, I again took statement of the two witnesses, namely Paran Orang and Lilabor Kurmi. After completion of my investigation, I filed a report against accused. Juvenile conflict law under Section 326/302 of IPC. Exhibit 4 is my report and Exhibit 4.1 is my signature. In cross, on behalf of accused, on 18/9/16 in the morning time, I went to place of occurrence. The Ejahar was filed in the morning at 10:30 a.m. on 18/9/16. And thereafter, I went to place of occurrence. I could not record the statement of witnesses, namely Zulika Kurmi and Bobita Kurmi and Bibes Rao, is shown in the sketch map. On the south of the sketch map, one shop is situated, but the said shop was closed, for which statement of the owner of the shop could not be recorded. I could not record the statement of the person shown in the sketch map. I could not seize any article at the place of occurrence. I have taken the statement of the witnesses, namely Ajoy Kurmi and Kamal Kurmi, at the police station. I had not taken any statement of witnesses in the hospital. The injured was admitted at the hospital at about 3 a.m. in the morning on 18/9/16. The victim at the time of admitting the hospital was in a condition respond to query. I have not recorded any dying declaration of the injured. On 29/16, the victim expired in the hospital. I have not mentioned the date of giving prayer of aiding Section 302 IPC in my case diary. I had not mentioned to whom, that is CJM or principal magistrate made the prayer for adding the section 302 of IPC. PW2 Ajay Kurmi has not deposed before me that deceased accused stabbed injury to Vikas Kurmi. PW3 Kamal Kurmi has not deposed before me that on the date of occurrence he was sleeping in the residence and after hearing hue and cry, he came to residence of Vikas and Vikas told him that accused Dinesh Rao caused stab injury to him. I had not recorded statement of any eyewitnesses in the instant case. It is not a fact that I have not conducted the investigation in the instant case properly. And on the basis of statement of witnesses, I filed a report against the accused Dinesh Rao. On the basis of his statement, my lord, that I raised a plea of juvenility where it was listed before my lord for hearing. Accordingly, that report has come. Accused is 21 years age of age. Now the doubt has already been cleared.
On
My
the basis of the certificate or ossification?
no ossification. Initially, guardian authority gave the certificate, my lord, but it is not the recorded authority, my lord. Thereafter, Honorable Court has directed for ossification, my lord. And that report says, my lord, may find in the order dated 27/11, my lord, and 8/1, my lord. He is of 21 years of age, my lord, as per report. So far as my lord, that recording of dying declaration, my lord, in cross, he is specifically admitted that his in a submission, he is in a condition to respond the query, but no query has been asked regarding his fitness, my lord, and as well as he did not record the declaration also. Though there is a time limit of in between 2-3 days has passed away, my lord. And so far as deposition of PW2 and 3 is there, my lord, it is stated that 161, they did not stated about that stabbing incident, my lord, by the name declaration.
What is there in the 313?
313, it's a denial, my lord.
Total denial.
Appears to be. I did not kill Barik Kurmi in page 25, respond to a question number 3, my lord.
He denies being at the place of occurrence.
Yes, please. And another question I found at page 27, my lord, question number 15. I said I did not kill Vikas. And question 13, I was at home. In 28, page 28, question 16. Do you want to say something? No, I was at home. I do not know anything.
17 also, no evidence.
Yes, ma'am. He is not adducing any evidence.
He could have brought somebody if he was at home, isn't it? If he was at home, he could have brought somebody.
Yes.
She knows that I'm at home. I was sleeping or something like that. So yes.
Positive evidence. As it was clear very
Though
well.
he was represented by the council also, my lord. He never make any application for defense witnesses also, my lord. He could have advised for naming that person who could depose on his behalf, my lord, setting his plea. But no such thing is there, ma'am.
So your main grounds for appeal is that
That fitness part, my lord.
fitness.
So far as his conviction is concerned, analysis is there, my lord, in the impugned judgment, my lord. That based deposed upon evidence of 1, 2, 3, 5, and 7.
One,
1, 2, 3, 5, and 7.
Hmm.
The final analysis on the learned court below granted that conviction, my lord. Because that stabbing part and injury part is corroborated, my lord. And to that extent, no examination is done to demolish their witnesses, my lord. On behalf of the accused, my lord. So here I found only submission regarding that mental fitness, my lord. Because that suspicion arises because the given two witnesses to whom before he deposed that he was stabbed by accused, my lord. They are interested witnesses
they're
also.
all related, so
So
she can
their family.
count them as interested witness. But what about the IO? IO also said somewhere
Yes.
that
Said, my lord, in
on asking him, he said that he was so and so.
but he did not record, my lord.
Not record, but
But-
regarding the mental health.
That part is there.
There's no certification about mental health, but he says that
Yes, yes, ma'am.
the victim at the time of admitting in the hospital
Victim told him.
was in a condition to reply.
While he was putting the victim on his vehicle, my lord, at page 21, he stated in his chief, my lord.
In chief,
Yes, my lord.
where?
Page 21.
Yeah.
1, 2, 3, 4, 5, 6, 7. 7 or 8 lines from bottom, my lord. That line starts from, I met the injured on my way to hospital. Lordship got it.
While I inquired into post that.
Yes, ma'am. I come to know that refer to James says better. I took the injured person in my official vehicle to JMCH, and there while I inquired, he deposed that accused Dinesh Rao caused stab injury to him.
Page 21,
Page 21, my lord.
the first paragraph. In chief.
Bottom, yes, in chief, my lord. 1, 2, 3, 4, 5, 6, 7 line from the bottom line. That line started, I took the injured person in my office vehicle.
Is it page 21? Or 21, yes.
21, PW, my lord, 7. Name is Giridhar Sharma.
That is one part, and in the cross-examination at 22.
Page 22, my lord.
Cross-examination, last two lines.
Last 2 lines. When he said that the victim at the time of admitting in hospital was in a condition, respond to query. I have not recorded any dying declaration of the injured. Secondly, my lord, my submission that no weapon, murder weapon has been seized, my lord, neither it is recovered. So to prove that in a full-fledged manner that he neither any blood stain has already been collected for forensic report also, my lord. For clearing all the doubt regarding the death of the person. On these two counts, my lord, small judgment exactly not related to the circumstance, my lord, facts and circumstance, but there is a independent thing regarding mental fitness that court has to take into the matters, look into the matters without
Is the
doubt.
judgment?
That here. Here two dying declarations are there, my lord. Some other, first one is corroborated by the other evidences, second one is not. On that, my lord, analysis, kindly see page, paragraph, my lord, 3, my lord. First few lines, it's independent to the facts, my lord. Para number 3.
Let me just restaple your compilation. It's upside down.
May not be wrongly, my lord. I apologize.
659.
May I correct it, my lord?
It's okay. I have my own stapler here. Yes, para 3.
Para 3, my lord.
Please read.
May I read?
Hmm.
An oral dying declaration, no doubt, can form the basis of conviction. Though the court seeks for corroboration as a rule of prudence, but before the said declaration can be acted upon, the court must be satisfied about the truthfulness of the same and that the said declaration was made by the deceased while he was in a fit condition to make the statement. The dying declaration has to be taken as a whole, and witness who deposes about such oral declarations to him must pass the scrutiny of reliability. Here I pose the question, as the other two witnesses who before whom he has deposed about the stabbing, my lord, they are interested witnesses as a family member, my lord. So it's while this court is granted that conviction, my lord, this factor was not looked into, my lord.
So does it mean that if in case of
Little, my lord, doubt is there.
interested witness, then the such kind of
No,
evidence is
here, my lord, I admit.
not reliable?
No, it's reliable if that chain is completed, my lord, in respect of, in lapse of any eyewitness, my lord. Here, no eyewitness is there, my lord. Neither the police tried to, my lord.
Perhaps if you take the plea of what do you call interested witness, in such a situation, I think court will have to be more careful in considering and examining how far it can rely upon. That caution has to be there. It's not that because somebody is related to somebody,
Yes.
so there's something wrong in it. It can be relied upon,
For
except
sake of
that.
argument, my lord, I am
Okay.
like to place this way, because otherwise there is no defense witness to demolish, my lord. That is eventually true, my lord. That cannot be denied, my lord.
Any other judgment?
No, my lord.
Only this.
Only this. For
Okay, we'll take a short break and come back and we'll hear the learned PP. Yes.
Lordship will take into account whether the lying declaration given to the witnesses concerned is truthful or can be reliable and can be the sole basis of conviction, Your Lordship. Apart from that, there are little bit of discrepancies here and there. First, I'll point out the discrepancies as regards the age of some of the witnesses. Lordship, PW2 Ajoy Kurmi, his name is shown to be 18 years while giving the deposition. Ajoy Kurmi minor. 18 years.
PW2.
Yes, Your Lordship. But in the charge sheet, my lord, his age is shown as 11 years, Your Lordship. And as regards another witness, PW3, Kamal Kurmi, his age is shown as 9 years in the charge sheet, whereas in this one, the deposition is, while recording deposition, it is shown as 17 years. At the same time, I'll make an alternative submission. Whether these persons are competent to testify, according to me, it is up to the judge who have taken the testimony when Lordship, when according to the, they passed that, Lordship, the competency test as regards their intelligence. As such, probably the learned trial judge did not take the other factor, whether the question answers and all, Your Lordship, to testify his competence. Lordship, but I don't know why his age is recorded as such.
17.
Lordship?
17.
17. 17 as well as 18. So date of occurrence is 16. His age was shown to be 11 years while submitting the charge sheet. But at the same time, it came in 2018 while recording deposition. It was 18 years now.
See, regarding the age factor, what is the limit in which the court will ask some questions
Yes.
generally,
Yes.
just to test whether the person can
Yes. I don't.
rationally answer the questions or not?
Yes, giving rational answers.
Uh-huh.
I don't find
Any age level on that?
fine.
Below 10 years?
Question is that it's up to the trial judges who
Below
have
12 years,
yes.
Usually it is done.
Yes, up to 12 years.
12 to 15, I think some discretion is there. But below
That
12 years,
factor
it
I'm
is
lordship because I didn't find
preliminary questioning.
my lord. So my submission is that it's up to the judge who takes up the testimony of the witnesses concerned. Lordship. So since the learned trial judges did not feel it necessary to take the other factors like to testify, Lordship. So in that regard, probably Lordship, he did not question the veracity of the statement given by the witnesses concerned.
Okay.
Lordship. Regarding the testimony given to PW1, PW2, PW3, and PW4. Lordship, whether your Lordship will take into account whether the statement given to those witnesses are reliable. In the sense, the Lordship will take into account whether the statement given by the victim, my lord, dying person, can be taken into account to uphold the conviction, your Lordship. One is the sister of, as well as the informant. Two, I find his father's name is different. And then Lordship may kindly have a look at evidence of PW2. He is not at all related to the victim.
Page 9.
PW2 page 9. The informant is my elder sister. Although he has stated to be his elder sister, I know the accused. I also know injured Vikas Kurmi. About 1 year ago, Manasa Puja celebration was held in line number 9 of our garden. I had gone to see Manasa Puja celebration. I don't know whether Bikash had gone to enjoy Manasa Puja celebration or not. While I was there at a place where puja was organized, Arjun came and informed me that someone had stabbed Vikas with a knife. On receipt of the information, I went to Vikas's house. He didn't say it is his own house. So, from father's name is Bharat Kurmi, whereas the father name of the victim as well as PW1 is Subhas Kurmi. And as well as the other factor that I went to Bikas's house, which proves that he is not related or own brother of the this one victim, my lord, as well as the informant. Reaching Bikas's house, I saw injuries in Bikas's stomach and that he was vomiting. Bikas told me that the accuser stabbed him in the belly with a knife. After that, Bikas's mother, elder brother, and I took Bikas to the hospital in the tea garden. And later, we took him to Jorhat Civil Hospital for better treatment. Bikas died at Jorhat Civil Hospital. In cross, I cannot say as to how many people were there in the place where puja celebration took place. I did not state before police that after coming to Bikas's house, I came to know from him that the accused had stabbed him with a knife. It is not a fact that I have falsely stated that Vikas has told me that accuser stabbed him. So this witness is an independent witness, Your Lordship, not related to the victim or the informant, Your Lordship. So, Your Lordship, apart from other two witnesses, one happens to be the mother and one is sister and another is another brother, right? So this is accused, this Lordship, I'm so sorry. This witness PW2 can be taken, his evidence can be taken into account, Your Lordship. So there is no embellishment, and I have gone through the entire evidence and record. Whatever has been stated to them is consistent throughout, Your Lordship. There are no inconsistencies as regards the statement given by the person dying, Your Lordship, the victim. Apart from that, from the evidence of IO, PW7, Lordship, may kindly have a look, my lord. PW7, the IO, page 22 down below. From his statement, it could be about, Your Lordship, the injured was admitted at hospital at about 3 a.m. in the morning on 18/9/16. The victim at the time of admitting in hospital was in a condition respond to query. So he was in a fit state of mind to give a statement before the witness is concerned. I know. And Your Lordship, whatever he has stated before the witnesses as regards the injury given by the accused person, it is consistent throughout and it corroborates with the evidence given by the doctor, my lord. The injury is on the belly, Your Lordship. May kindly have a look, my lord. The evidence given by Dr. PW6. Lordship, page 80. Wounds, position and character, page 18.
Yes.
Stitched wounds of size 2 cm is present over the left side of the abdomen, 3 cm below the umbilicus and 11 cm lateral to the midline. On opening the stitches, the wound is buttonhole shaped with regular margins. On reflection of the layers of abdomen, the wound is found to be cavity deep, perforating the large intestine, stay wound. The back of the wound, the skin, soft tissue, muscles and peritoneum are pierced, entering the peritoneal cavity and perforating the large intestine direction, front to back, left to right, and almost horizontal. No ligature mark, healthy and dissection. And Your Lordship, the opinion of the doctor on large intestine and its contents found perforated along the anti-mesenteric border is the left side of the abdomen. Opinion as to the cause of death, it was due to shock and hemorrhage following injuries sustained and described. Injuries antemortem and caused by sharp pointed weapon homicidal in nature. So it's consistent throughout, Your Lordship. Although, my lord, some of the witnesses, Chotu and Arjun, was not examined as a witness, and although Lordship weapon of offense is not seized, I don't think it's fatal to the prosecution case when the witnesses are considered throughout, Your Lordship, and it corroborates the evidence given by a doctor, opinion given by a doctor, Your Lordship. Although my learned friend has not taken the plea, it's a case of single injury, my lord. Lordship, whether Lordship will kindly judge, my lord, whether the injury given by the accused concerned is sufficient to cause death. So in the event of the matter, Lordship 302 is Lordship the provisions as advised in section 299 is satisfied, Your Lordship. All right.
299.
299, yes.
Culpable homicide.
Yes. Culpable homicide. Lordship, whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death, with the knowledge that he is likely to such act or cause death, commits the offense of culpable homicide. Lordship,
Yes.
to bring it under the exception, some intention, knowledge, those parts are there. But when the evidence, Lordship, statement given by the victim is consistent throughout, and it corroborates the evidence of the medical evidence, medical witness, doctor, Lordship, in that event of the matter, and since it is, Lordship, the injury given by the person died as a result of the injury is, although not instantaneous, Your Lordship, but the gravity of the injury is, Lordship, too much, Your Lordship. It pierced throughout his vital part, it's on the stomach. So I leave it to your Lordship's discretion whether this case can be brought into the any of the general exceptions. My lord. And in the case of Lordship,
There is no evidence as regards the circumstances which led to the injury, isn't it?
yes, there's nothing.
Simply stab wound and he
Yes.
was taken
My
and
lord.
he said, I was stabbed.
My lord.
That much only.
Lordship. Although the attending doctor was not examined, I have found one document, Your Lordship. He was first taken to a
Garden hospital.
Garden hospital. But that document has not been exhibited. Then thereafter he was referred to Gauhati Civil Hospital. A flag mark, my lord. Here, Vikas Kurmi, to the OC Senior Medical Officer, Kunwal Tea State. I would like to inform you, a patient of LA stab injury was brought to the Garden Hospital on 2 a.m. on, so Lordship 2 a.m., although it is not exhibited document, my lord, 18-9, as per reference above. Looking at the seriousness of the patient's condition, he was referred to Jorhat Medical College Hospital immediately. For your kind information and needful. That is there, but it was not exhibited, man. No, none of the other medical documents are not there, whether any medicine has been prescribed or administered to him. Nothing is there, Your Lordship.
Why did this stabbing incident happen? Nothing is there.
Nothing is there, nothing.
Yeah.
So under that circumstance, are we required to examine that aspect?
Leave it to your Lordship. May not, my lord, because Lordship, when the evidence, Lordship statement given by a dying person, Lordship truthful, it has full sanctity in the eye of law, my lord. So Lordship may not go into that account. Even otherwise, in account of eyewitnesses, in cases where eyewitnesses account is there. So motive part is not a vital factor, Your Lordship. So Your Lordship will charge
Still it's
whether
not clear.
Lordship.
Why is,
Yeah, those
there's
things
no,
are happening.
there's no evidence to indicate any fight
Yes,
or any enmity.
my
We
lord,
do not
nothing
know.
is there. Only mother says, I do not know whether he went to see television in the house of the accused person. Nothing is there. So Your Lordship will judge whether
In fact, my lord, in the evidence of PW 3, my lord, page 12, in chief, it is clearly stated that my brother died at Gauhati Civil Hospital because did not tell us as to why he was stabbed. Page 12.
You did not tell us.
Probably he tried to get the reason for this incident, my lord, but he did not tell.
He is not his own brother, Lordship will kindly note.
Maybe, my lord, but
W2.
that
Cousin, but
Maybe cousin, my lord.
cousin related person.
And
evidences did not try to get that information.
Who is the mother? PW?
PW, mother,
Five.
PW, 5, Aruna Kurmi.
Now, could be.
Naturally, they are the persons, my lord, mother, sister, and the brother. They were at home. The accused came and the victim came and reported to them, my lord, at the first instance. Lordship, may I take your lordship to section 32 of the evidence? Eh?
Probably it's upside down, some of them.
Cases in which statement of relevant fact by person who is dead or cannot be found, etc., is relevant. Statements, written or verbal, of relevant facts made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expense, which under circumstances of the case appears to the court unreasonable, are themselves relevant facts in the following cases. When it relates to the cause of death, when a statement is by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death in cases in which the cause of the person's death comes into question. Such statements are relevant whether the person who made them was or was not at a time was or was not at the time when they were made under expectation of death, and whatever may be the nature of the proceeding in which the cause of his death comes into question. Lordship, in the present case, although there is no right declaration is not in written form, so Lordship will kindly judge the verbal or oral dying declaration given to the witnesses enough to uphold the conviction, Your Lordship. My respectful submission is that it is consistent, truthful. So, Your Lordship, the dying declaration given by the victim is the sole basis for conviction, while the learned trial judge, while doing so, has rightly upheld a lordship, convicted the accused person, Your Lordship. And in the event of the matter, Your Lordship can be uphold the conviction given by the learned trial judge. And the defense could not demolish the veracity of the statements, the evidence given by prosecution witnesses by way of cross-examination. Lordship, may I be permitted to place two citations? 2008-7 is it up to date?
Regarding the
2008?
question of whether it can come within 304 part 1 and part 2.
That Your Lordship will just,
There are no sufficient metrics.
yes, yes. Whether there is any grave or sudden provocation, yes,
Single injury, no doubt. But
Yes.
on the
vital part of the
Right.
body.
Vital part, single injury, that conviction may be sustained also. That is why I could not take that plea, because that medical report shows that injury part minor, which is a vital one. So single injury sometimes may cause of death.
2008,
Effect-
17, 2008, 17 SCC 190. Selvam versus State of Tamil Nadu. Para 7. Para 7, and it may read your lordship. Para 7,
This is on which point?
lordship. Oh.
This is regarding?
Regarding veracity of the dying declaration, my lord.
Okay.
Para 7, this is a case where the basis of conviction of the accused dying declaration. Has your lordship got it?
Yes.
The situation in which a person is on his deathbed, being exceeding solemn, serene, and grave, is a reason in law to accept the veracity of his statement. It is for this reason that the requirements on oath and cross-examination are dispensed with. Besides, should the dying declaration be excluded, it will result in miscarriage of justice because the victim being generally the only eyewitness in a serious crime, the exclusion of the statement would leave the court without a scrap of evidence. Though a dying declaration is entitled to great weight, it is worthwhile to note that the accused has no power of cross-examination. Such a power is essential for eliciting the truth, as an obligation of oath could be. This is the reason the court also insists that the dying declaration should be of such nature as to inspire full confidence of the court in its correctness. The court has to be on guard that the statement of the deceased was not as a result of either tutoring or prompting or a product of imagination. The court must be further satisfied that the deceased was in a fit state of mind after clear opportunity to observe and identify the assailant. Once the court is satisfied that the declaration was true and voluntary, undoubtedly, it can base its conviction without any further corroboration. It cannot be laid down as an absolute rule of law that a dying declaration cannot form the sole basis of conviction unless it is corroborated. The rule requiring corroboration is merely a rule of prudence. Para 9. This court has laid down in several judgments the principles governing dying declaration, which could be summed up as under indicated in Paniben versus State of Gujarat. There is neither rule of law nor of prudence that dying declaration cannot be acted upon without corroboration. If the court is satisfied that the dying declaration is true and voluntary, it can base conviction on it without corroboration. The court has to scrutinize the dying declaration carefully and must ensure that the declaration is not the result of tutoring, prompting, or imagination. The deceased had an opportunity to observe and identify the assailants and was in a fit state of mind to make the declaration. When a dying declaration is suspicious, it should not be acted upon without corroborative evidence. When the deceased was unconscious and could never make any dying declaration, the evidence with regard to it is to be rejected. A dying declaration which suffers from infirmity cannot form the basis of conviction. Merely because a dying declaration does not contain the details as to the occurrence, it is not to be rejected. Equally, merely because it is a brief statement, it is not to be discarded. On the contrary, the shortness of the statement itself guarantees the truth. Normally, the court, in order to satisfy itself whether the deceased was in a fit state of mind condition to make the dying declaration, looks to the medical opinion. But where the eyewitnesses have said that the deceased was in a fit and conscious state to make the dying declaration, the medical opinion cannot prevail. Whether the prosecution version differs from the version as given in a dying declaration, the said declaration cannot be acted upon. Where there are more than one statement in nature of dying declaration, the one first in point of time must be preferred. Of course, if the plurality of dying declaration could be held to be trustworthy and reliable, they have to be accepted. Lordship, in the event of the matter, Lordship, may I make my respectful submission? Here, the victim was consistent throughout, Lordship. So before he deposes before the IO, who probably did not come at the first instance because the victim came home first, and when he was asked what happened, then he talked to his brother, sister, as well as to his mother. So, Your Lordship, from the evidence of PW1, 2, as well as from 5, Your Lordship, not 2, Your Lordship, PW1, 3, and 5. So, Your Lordship, can be gathered, Your Lordship, he was in a peace state of mind. Lordship, apart from that, Lordship, from the evidence of IO, Lordship, it could be gathered that he could answer the query, which means that he was in a fit state of mind, Your Lordship. So in the event of the matter, Your Lordship, the statement given by the victim, Lordship, is consistent and truthful, Lordship, and In the event of the matter, your lordship, on the basis of sole dying declaration, not sole, your lordship, there are 3 dying declaration, but there are, I mean to say, the dying declarations are given to 2-3 persons. They're consistent throughout, and in the event of the matter, your lordship will take into the account that factor and uphold the conviction. Lordship, another judgment I'll be relying on 92 SCC. 474. Para 17, my lord.
Para
17.
This was referred to, right? In Pani-
92 to Paniban, yes.
Para 17.
17. The situation in which a man on deathbed is so solemn and serene when he is dying, the grave position in which he is placed is reason in law to accept the veracity of his statement. It is for this reason the requirements of oath and cross-examination are dispensed with. Besides, should the dying declaration be excluded, it will result in miscarriage of justice. Because the victim being generally the only eyewitness in a serious crime, the exclusion of the statement would leave the court without a scrap of evidence. Para 18. Though a dying declaration is entitled to great weight, it is worthwhile to note that the accused has no power of cross-examination. Such a power is essential for eliciting the truth as an obligation of oath could be. This is the reason the court also insists that the dying declaration should be of such a nature as to inspire full confidence and the court in its correctness. The court has to be on guard that the statement of decease was not as a result of either tutoring, prompting, or a product of imagination. The court must be further satisfied that the deceased was in a fit state of mind after a clear opportunity to observe the identified assailants. Once the court is satisfied that the declaration is true and voluntary, undoubtedly, it can base its conviction without any further corroboration. It cannot be laid down as an absolute rule of law that the dying declaration cannot form the sole basis of conviction unless it is corroborated. The rule requiring corroboration is merely a rule of prudence. This court has laid down in several judgments the principle. So I think, Lordship,
This was referred to in the
earlier
earlier
cannot raise it further. Regarding the plea of alibi taken by defense, my lord. So, Lordship, in 313, in 313 he said he was somewhere else, but Lordship, plea of alibi has to be brought by a positive evidence. So, Lordship, he could not adduce any evidence to that effect, Lordship.
Yes, that's it.
Lordship, that's it, my lord. Probably the prosecution could prove the case beyond a reasonable doubt. In the event of the matter, my respectful submission is that the Lordship will uphold the conviction.
Right. All right, counsel for the appellant, anything else to add?
Lordship, nothing else because of that,
You are the legal aid counsel or the
my cousin.
engaged? Oh, you're the amicus. Okay.
So far as his statement recorded under 313, his age was 21 years in the year 19 So seeing that his tender is minor, some leniency may be provided.
Also, I also make the submission. At the time of recording,
313.
313 in 2017, he was 21 years and date of occurrence, Kitya? Date of occurrence?
16.
16.
1816.
18/6/16, so he would be of 20 years. I leave it to your Lordship discretion.
20 years at the time of death.
Yes. So Lordship is just age of the accused person, Lordship vis-a-vis the gravity of the offense, my lord. The manner he was like injury, Lordship. I leave it to your Lordship's discretion.
What is the punishment prescribed for 302?
520 or something. 202.
Death or life.
Oh, yes.
You told like,
Life means the entire Lordship.
There's no scope of leniency, isn't it?
There are judgments, your Lordship. At the same time, my lord, the victim was also the person dying. He was also Lordship on age. He has taken the life of a young person. PM report says, my lord, is 50. "17 years, my lord. Deceased was of 17 years.
The question is whether he can be attributed with the intention to cause it.
Yes.
If not, then some conversion may be possible.
Leave it to
Otherwise-
yes, there are judgments to that
To
effect.
that
yes.
extent, I humbly submit, my lord, that defense plea is not there, actually, for,
There's no hint anywhere to that
Yes.
effect.
Yes.
yes.
That's why. All right, we'll consider and pass necessary orders.
Lordship, as regards, whether compensation has been awarded, my lord, I'll see to the victim's family. I know, I think it's not there reflected in this one. So in the event of the member, Lordship, it may be legal services ought to be directed to award
Yes.
compensation as in terms of the scheme provided by the LSC, Lordship.
It's not there.
This is item 12, is it?
12, no, item.
Item 12.
We'll reserve the judgment, brother. Hart. Miss Burman, M. Burman, learned amicus curiae for the appellant, and Miss B. Bhuya, learned additional public prosecutor, Sam. Stop the learned counsels for the rival parties have made their respective submissions. The hearing is concluded, judgment reserved.
Obliged.
Obliged, Lordship. Citation to the label,
Send it to the chamber, huh?
LCR to resolve.
Item 30,
13 author. Some.
May I please answer?
Yes.
My lord, a case of sorry side, my lord, husband killing the wife, my lord. And my lord, the conviction was basically based on 3 counts, my lord. First is extrajudicial, my lord. There was no eyewitness, extrajudicial. Second is section 27 of the Evidence Act. It was the case of the prosecution that accused led to the recovery of the weapon, my lord. And third was the 106 explanation, my lord. There was no sufficient explanation on the part of the accused. Since, my lord, the incident happened at 3 a.m. in the early morning hours, my lord. And cases of 302 and 436, my lord. Mischief by causing fire to the house, my lord, dwelling house, my lord. Now, my lord, the FIR is at page 4, my lord.
Yes, please read.
My lord, he is the informant is the neighbor of the, my lord, accused. I have the honor to state that around 3 a.m. today, on 22/1/2019, accused Sri Atwa Munda, son of Sri Supu Munda, resident of Oranguli Tea State, killed his wife Regina Munda on the bed itself by hacking her with a dao in the neck. Since their house was set on fire, all the articles in their house got gutted down. I therefore plead to you to take necessary action upon investigation the matter obliged. And my lord, after registration of the FIR, my lord, the investigation was taken up. Thereafter, my lord, charge sheet was filed. And my lord, page 7, your lordship would find the case was committed to the Court of Sessions, and page 6 is the charge sheet, my lord. Charges framed, my lord. Page 6. Page 6, my lord. The
Hmm.
charges were framed on 2 counts, my lord, 302 and 436, my lord.
Yes.
To which the accused pleaded not guilty and he claimed to be tried, my lord. Now, my lord, PW1, page 8, my lord. The doctor conducting the postmortem, my lord.
Hmm.
May I read, my lord?
Yes.
On 22/1/19, I was working as MNHO at Udalguri Civil Hospital. On that day, I examined one Rajan Munda, aged 40 years, female, in connection with Paneri PS case.
5 minutes, I'll come back, call from another call.
Sure, sure.
Connection with Paneri PS case number 9 of 2019 under section 302/436 IPC. Brought by UBC 338 Rinkutas. On examination, I found the following. External appearance, an average built female body wearing green mekhla and red blouse. Cut injuries seen right side of the neck. Cardiac body cut hemorrhage seen in skull, vertebrate, membrane, brain, spine cord, all are intact. Now last, my lord, would sign more detailed descriptions, my lord. The injuries, my lord, cuts, injuries seen over the right side of neck, 7, some says it was fully gutted.
Despite that, this kind of injury has been
Yes,
found
yes, my
by
lord.
the doctor
Yes,
during the PME, isn't it?
yes. Page 9 is the opinion, my lord. In my opinion, death is due to hemorrhage shock following antemortem cut injury. Time since that 9 to 12 hours.
Hmm. Yes.
Now, my lord, page 10, my lord.
Hmm.
However, my lord would appreciate one part, my lord. The GD was registered by one Rajan, my lord. The first information, my lord, through the GD entry was given by one Rabin Gwala. However, the FIR was filed by this PW2, my lord. Dominic Orang, my lord, PW2. He is also a worker in the tea garden, my lord. May I read, my lord, page 10, my lord?
Yes.
I am the informant. I know the accused Atwa Munda, who is the father-in-law of my cousin, son of my elder sister. The incident occurred on 22/1/2019. On that day of incident, I was staying at my basti at Uttar Goraija, Jora Basti, as I was looking after my cultivation at Jora Basti. During that time, I asked accused Atwa Munda to stay in my original residence in line number 20, house number 55 at Oranguli Tea Estate. However, at 4 p.m., Rajan, who is my next door neighbor at Jora Basti, received a phone call that there was a murder in my residence and my house was burning. Rajan immediately conveyed this message to me. Hearing this, I, along with Rajan, immediately rushed to my original house in my own scooty. On reaching the spot, I saw my entire house gutted. Now he says entire house gutted. But the burn injury were never found on the body of the victim, my lord. And the body of Regina Munda, wife of Atwa Munda, was found lying on the courtyard of my house with cut injury on her neck. Now her body was found in the courtyard, my lord, outside the house. Having seen the scene, I was almost broken down as my house was already burnt. After a few minutes thereafter, accused Atwa Munda came to my house. Now the accused thereafter came, my lord. It is to be noted that before I reached the spot, police personnel and villagers already gathered there. Then the accused Atwa Munda confessed before the public and police that he committed the crime. Accused Atwa Munda also handed over the doubt to the police which he committed murder of his wife. Well, this part is very relevant, because this witness says that Atwa Munda also handed over the doubt to the police. Whereas, my lord, in the seizure list, it was in the evening at 5:30, the alleged weapon was seized, my lord. It was not seized in the morning, my lord. My lord, take the recess, my lord.
Yes. We'll resume at 2.
Also handed over the doubt to the police with which he committed murder of his wife. Police then seized the dhow, but I did not sign in the seizure list as witness. During investigation, police also recorded my statement. Exhibit 2 is the FIR. Exhibit 2.1 is my signature. Now cross, my lord, page 11. Only this much I'll do thereafter. I did not see the incident who committed the crime. I did not see the incident who committed the crime. Accused led the police where he kept the offending dhow hidden and then shown the same to the police who seized the dhow. It is not a fact that I did not state before the police that accused Atwa Munda confessed about the commission of the crime in presence of the public and police. It is not a fact that accused did not committed the murder and I depose. False. Yes.
My lord, before your lordship rises, my lord, item 14, my lord, I am appearing for the informant, but I have not been supplied with the paper book copy, my lord.
It's a POSCO matter, lordship.
So my learned friend is for the appellant side. I have also talked with him, my lord. So office will be directed to supply me a copy of the paper books, and the matter may be kindly taken up at your lordship convenience at any date.
Please write item 14.
14.
Mr. M.H. Rajbarbhuya, learned counsel, appearing for respondent number 2, bracket informant, submits that he has not been furnished with a copy of the paper book. Stop. Registry shall furnish the paper book to Mr. M.H. Rajbarbhuya, learned counsel, and thereafter list this matter. When do you want it? Anyone for the appellant?
But learned friend is appearing for the.
Yes, sir. Actually, I am for that.
My
Please
friend
put a
is for the appellant
Can it
side.
be fixed on 4th of March, Lord?
It's a holiday. 3rd and 4th is a holiday.
Uh,
You can have it on
after 21st.
10th of March.
10th of
It's a
March.
Tuesday hearing day.
Lordship. Lordship.
List on 10th March.
No, sir.
It's always no problem. Yes, you may start.
Yes, my lord. My lord, page 12, PW3, my lord. Page 12, my lord. Now, he is the person who informed the police, and on the strength of his information, my lord, the GD was.
Yes.
On the information of this witness, my lord, the entry was taken, my lord, by the concerned police station, and thereafter, my lord, the police came to the place of occurrence, my lord, as per the GD entry, my lord. May I read, my lord? I know the accused Atwa Munda, who belong to my same village. I also know Regina Munda, wife of accused. The incident occurred about 2 years back. At the time of incident, I was at my residence, but I heard from neighbors that accused, after killing his wife, set the accused house on fire. Hearing this, I immediately rushed to the house of the accused and saw the dead body of the deceased lying on the bed. Now he saw the body lying on the bed with cut injury on the neck with bleeding and saw fire on the roof of the house. Then we together put out the fire and informed the Paneri PS. The incident occurred around 2:30 to 3 a.m. After setting the house on fire, accused fled away, but when police came, accused emerged on his own in his house. Then in our presence, police took accused under police custody. Dead body was also taken by police. Police also seized a dhow by the side of the dead body. This is important, my lord. Now, this witness says that the weapon of assault was seized by the side of the dead body, my lord.
PW2 said accused handed over the dhow to the police.
PW2 said that he handed over the dhow, and PW3 says that police also seized the dhow by the side of the dead body.
And the body was lying inside the house.
Inside the house.
PW2 says it was outside in the
Outside,
in the courtyard.
In the courtyard.
So PW2 came later on. Who arrived earlier? Two or three?
Rajan, because on the strength of his, but Lordship would find the first person to reach was Paresh Ram Munda, PW4, my lord, as per his. It is in page 14, my lord.
Okay. Thereafter, who came?
Thereafter, he says that the nearby villagers all came, and thereafter they tried to pour water on the burning place, and two of them went inside the house and brought the dead body from the inside the house to the courtyard, my lord. This is what the evidence has come.
So when did the PW3 and 2 arrive at the place?
My lord, as far as this part is concerned, my lord, nobody has said about these witnesses, the other who came first, my lord. They did not spoke about these two witnesses.
And who is PW3?
PW3 is the person who initially informed the police, my lord.
Initially?
After reaching the place of occurrence, my lord.
Then 2 is also the informant.
2 is the informant.
So police was informed twice?
Yes, my lord. Because no, my lord, written HR was filed by this Dominic Orang, my lord, PW2, and the information for the GD entry was provided by this witness, my lord, PW3.
PW3.
Yes, my lord. I'll just take your lordship to the GD entry, my lord. Lordship would find the GD entry.
Page.
Just a second, my lord. Page 80, my lord. 80. May I read, my lord?
Yes.
Now, Sri Rabin Gwala, resident of Orangjuli Tea Estate, informs over phone that Sri Atwa Munda, resident of line number 20 of Orangjuli Tea Estate, killed his wife Regina Munda by hacking her with a dhow in the neck, and later on set fire to his house and makes a request to send police there. Accordingly, an entry in the GD has been made, and I, the OC Paneri PS, along with ASI Ibrahim Khalilullah, UBC 14 and Akhil Bosha, and one section of SSB have proceeded to the place of occurrence. ASI Anil Basumatri remains in the charge of the general diary. It is mentioned here that ASI Ibrahim Khalilullah has been entrusted with the responsibility of investigating the case. So on the left hand side, lordship would find 22/1/19. Time is 3:50 a.m.
He informed by phone.
Yes, informed by phone.
He informed by phone.
He informed by phone.
And number 2, PW2 has written the FIR.
Yes,
Or this signed this FIR.
yes, signed the FIR.
Alright.
Now, my lord, he says police also sees a dhow, PW3, my lord, page 12.
Yeah.
Police also sees a dhow by the side of dead body, but I was not a seizure witness. During investigation, police recorded my statement. Now cross. I was not informed about the incident by the villager. I was informed about the incident by the villager, but could not remember the name of the person who informed me. I have heard accused killed his wife, but I have not seen it. I could not remember whether I told before police that after committing the murder and setting the house on fire, accused fled away. So my lord, he says that he does not remember that part. That he said to police that the accused has killed his wife and thereafter set the house on fire. Now, my lord, most important, I did not meet the accused on the spot. Accused sometimes behaves abnormally, but I do not know whether accused has taken any medical treatment for this. The house contains two parts where the accused resides. In the other part of the house, another family resides, namely Rabi Sangha and his family. I know that there is residence of Phillips in front of the house of the accused, but I do not know exactly who resides on the northern and southern side of the house of the accused. Now, my lord, PW 4, page 14. Now, he was the first person to raise.
Yes.
Paresh Ramunda. I know informant Dominic Orang and also accused Atua Munda. I also know the deceased Regina Munda. The incident occurred on 22/1/2019 about 3 a.m. I was then sleeping in my house. My house is adjacent to the house of the accused Atwa Munda. Then I heard Atwa Kachua shouting as fire, fire. Hearing him, I got up from my sleep and ran towards the house of Atwa Munda. Then I saw the fire from the house of Atwa Munda is gradually engrossing towards our house. So I climbed to the roof of our house and put off the fire by throwing water with bucket. In the meantime, our neighbors Sankar driver, Birsing Sangha, Junos Triki, Raju Munda, etc. were present, who also assist in extinguishing fire. Thereafter, fire brigade party as well as welfare officer of Orangjuli Tea State also reached the spot. Then after entering inside the house of Atwa Munda, the neighbors, Jakaria and Jogen, now Malo, these two witness person who brought the dead body inside from the house, they were not examined in this case. Jakaria and Jogen brought out the wife of the accused Atwa Munda from inside the house with cut injury on her neck, and she was dead by this time, but her husband Atwa Munda fled away. But around 5 a.m., when people were gathering in the house of Atwa Munda, accused Atwa came and confessed in my presence, as well as in presence of other villagers, namely Sankar driver, Birsing Sangha, Junos Tikri, Raju Munda, Jakaria, Jogen, and Robin Gwala, the president of all Assam Adivasi Student Association, etc., that he cut the throat of his wife with kalam katari, an instrument made of iron used for cutting tea plantation, and thereafter he fled away by setting the house on fire. Then Robin Gwala informed the matter to police. Then accused Atwa Munda was handed over to the police and FIR was also lodged later on. Now cross, my lord. I have not seen personally who set the house on fire or who cut the throat of the wife of the accused. Police recorded my statement during investigation. It is not a fact that I did not state before the police that accused Atwa Munda set his house on fire. It is not a fact that I did not state before police that accused confessed his guilt of cutting the throat of his wife and setting the house on fire. I did not talk with the accused regarding the incident. Police was not present when accused came back to the house around 5 a.m. Police reached the spot after 25 minutes coming back to his house. I left the house of the accused before he came back to his house. So, my lord, he says that he left the house of the accused before he came back to his house. So, meaning thereby he has not seen what time the accused has come. I left the house of the accused before he came back to his house. When I again came back to the house of the accused, I saw police in the house of the accused. When accused made the confession before the public, police personnel was also present. I have heard that before accused made the confession, he was assaulted by the public gathered there. My lord, this part is very important. Because, my lord, in order to have an fair and voluntarily confession extrajudicial, even if we take, my lord, that should not be, my lord, coupled with threat, coercion, or misrepresentation or undue influence, my lord. So he was assaulted, that part has come, my lord. It is not a fact that accused was forced to confess under threat and assault. I did not state before police that accused cut the throat of the accused with kalam dao, katari dao. Now PW5, my lord, page 16.
So before that, this PW 4,
4, my lord.
he went away, came back again, he went
Again,
away,
my
came again.
Yes.
Twice.
Twice.
First time he would not come back, the accused person. Second
Yes.
time when he returned, he saw the accused had come back.
Yes.
Police was there.
And
Public were gathered, they had assaulted him and he had confessed.
yes, madam. This has come, madam.
Chief, you said that, also was present, he made the confession.
Yes.
Thereafter, police was informed.
Yes.
Was.
No, before police and public, he confessed. Yes, my lord. He says that, my lord. Part.
In the cross, he said,
Now, in the
the chief of.
chief also, my lord.
No, he had.
No, my lord.
didn't
He
mention
did not
about
say.
police and chief.
No, he did not mention that, my lord. Page 16, my lord, PW5. Now, as per his evidence, my lord, he was the first.
PW5.
PW5, my lord. He says that he was the first who saw the fire.
He is also the neighbor.
He is also the neighbor, my lord. And PW4 corroborates that hearing his voice, he wake up. PW4 hearing the voice of PW5, he woke up and came out of his house and saw the fire.
Who was shouting that there was a fire?
Atwa Kachwa, my lord, PW5, my lord.
I see. Atwa Kachwa is PW5.
Yes, PW5.
No, he shouted, fire, fire.
PW5 shouted and PW4 came
Yes,
hearing the
yes,
shouting
yes,
of
yes.
PW5.
Dominic, Sankar, Raju,
Yes.
Chakaria.
May I read, my lord? I know the informant as well as the accused. I know the deceased Regina Munda. The incident occurred on 22/1/2019 at about 3 a.m. while I was coming out in response to call of nature. I saw fire engross the house of accused Atwa Munda. Then I shouted as fire, fire. The neighbor named Dominic Orang, Sankar, Raju, Jakaria, Jogan, Poresram, Munda, Phillips, Rabi, along with few others villagers gathered there. Jacarias and Jogan brought out the dead body of Regina Munda from inside the house with cut injury on her throat. I assisted in putting out the fire. Later on, accused confessed before public about killing his wife. I also heard accused making the confession. Accused fled away after setting his house on fire. Around 5 a.m., accused came back to his house and admitted his guilt. Police came and recorded my statement. Cross, my lord. I have not seen who set fire on the house of the accused. I have not talked with the accused. Accused was not threatened or assaulted by public on the day of incident. Police was present while accused made the confession of killing his wife and setting his house on fire. My house is adjacent to the house of the accused. Accused came back to his house later on after the fire was put off. It is not a fact that I stated before police that accused made the confession before me as well as the other public. I have not seen the dead body. I do not know whether accused voluntarily made the confession or at the threat and pressure of the public. So now, my lord, he says in the cross that he does not know whether accused voluntarily made the confession or at the threat and pressure of the public. Robin Gwala and welfare officer of Tea Garden also came. I do not know whether Robin Gwalal assaulted or threatened the accused. Now PW6, my lord. Basil Champai. I know the informant Dominic Orang and accused Atwa Munda. Victim Regina Munda was the wife of accused. In the year 2019, the occurrence took place on the date of occurrence while I was in my residence at 7:30. This might be wrongly mentioned, my lord, because others have been consistent about the time of the incident. One Sankar Orang informed me that the house of the accused was burning. At that time, accused Atwa Munda was resident of Dominic Orang. Then I immediately rushed to the spot and found the whole residential house of the accused was engulfed by fire. Then by pouring water, the fire was controlled. Then we searched the house. So, my lord, the other witnesses also says that Basil came immediately. along with Jakaria, Jogens and other villages, my lord. Then we search for the accused. Accused arrived at the place, and on question made by villagers, the accused brought out the dao by which he had given the stab injury on the neck of his wife. So, my lord, here again the weapon is being said to be brought by the accused. Accused also confessed his guilt before public. Then police was called and the accused was handed over to the police. Cross-examination, my lord. I cannot say by whom the house was set on fire. I also did not witness when the victim was given the blow by dao. When the house was engulfed by fire, at that time the accused was not there. The police arrived at the spot before arrival of accused. When accused confessed his guilt, the police personnel were also present. I did not talk the accused personally. At the time when Jakaria's driver Robin Gwala were present. It is not a fact that I did not state before the police that accused brought out the dao from the place where the dao was hidden. Accused was physically assaulted by some persons when he arrived at the place. So, my lord, again, your lordship would find PW 6 states that accused was physically assaulted by some persons when he arrived at the place. It is not the fact that the accused did not confess the guilt and accused only gave the statement on inducement under threat. On the date of occurrence, my statement was recorded by the police. One part of the house was occupied by one person, namely Shanti. It is not the fact that I was not at the place of occurrence and I have no personal knowledge about the occurrence. It is not a fact that I have deposed falsely. So, my lord, this witness, two parts have come, my lord. First is that the accused brought the dao. And second part is that he was assaulted the moment he arrived at the place of occurrence, my lord. PW 7, my lord. Goga Munda. He is also a tea garden laborer, my lord. I know the informant Dominic Orang and accused Atwa Munda. Victim Regina Munda was the wife of accused. On 22/1/2019 at evening, the house of accused was engulfed by fire. It must have been morning, my lord, but somehow it is written as evening. After hearing the alarm raised by the people, I came out. I came to the spot. The fire was controlled with the help of water tanker of tea garden. The dead body was of wife of accused was found lying inside the burnt house. Police came and took away the dead body. I came to know from village people that after causing death, the accused set the house and victim on fire. Cross-examination. There is a house between the house of accused and my house. The occurrence took place at 2 a.m. of midnight. About 60-70 persons gathered at the spot before my arrival. Police arrived at the place at about 3 a.m. At the time of my arrival, accused was not there. After arrival of police, accused came out and he was assaulted by Robin Gwala. So now this witness also says that the accused was assaulted. Police interrogated me. I did not witness when the house was setting on fire and when the wife of accused was murdered. I have no personal knowledge about the occurrence. I did not state before the police that accused has admitted his guilt before the public. Now PW 8, my lord. Kanak Chandra Sharma. Now he is the Caesar witness number 1, my lord. Now, before taking this evidence, my lord, I'll just take your lordship to the Caesar list, my lord. Page 71, my lord. Now, my lord, number 1, date and time of Caesar, my lord, would find 22/1/2009 at 5:40 p.m. evening. Place of seizure, place of occurrence, my lord. So, my lord, there are discrepancy in the witness statements as well as the seizure list, my lord. Now, description of article 1, about 1 feet 7 inches long dowel fitted to a wooden handle. The length of the handle is about 8 inches with the ferrule. Black rubber is wrapped around the handle of the dowel. Dowel is stained with blood. My lord, this part is important, my lord. Because of the fact, my lord, FSL is very much required if, my lord, the weapon of assault have a blood stain, my lord. Some burn remains. Now, my lord, would kindly come to PW 8, my lord. Page 21. Kanak Chandra Sharma. I do not know the informant Dominic Orang, but I know the accused Atwa Munda. In the year 2019, on one day, police came and recovered one dowel left on the roadside in front of my quarter at Orangjuli Tea State. Police seized the dowel in presence of me and obtained my signature as witness. At that time, I came to know that accused Atwa Munda has caused murder to his wife by giving the blow of dowel. I could identify the dowel produced before me, which was seized earlier in my presence. Exhibit 3 is the seizure list. Exhibit 3.1 is my signature. Material Exhibit 1 is the dowel produced before me. Now, cross-examination. I am residing as the, it should have been at, my lord, at the staff colony quarter of Orangjuli Tea State, Atwa. Munda was also residing at the quarter of Tea Garden. Atwa Munda was working as temporary labor at Orangjuli Tea State. Being the temporary employee, he is not entitled to tea quarter. I cannot say in which line of the tea garden Atwa Munda was residing. The distance, now this is important, the distance between my quarter and the quarter of Atwa Munda is about 2 kilometers. Police showed me the dowel after recovery. At present, I cannot say whether there was any blood stain on the dowel. Today, I cannot say whether the dowel produced before me on today was actually recovered by police when it was seized in my presence. On the day, I, along with welfare officer, were only present with police. The signature on seizure list was taken in my quarter. So, Lordship would appreciate place of occurrence in his quarter is 2 kilometers difference, my lord. So, the signature was taken at the quarter. On that day, my signature was obtained on a blank paper. I signed on the seizure list in the early morning of that day. I have no personal knowledge about the occurrence. I cannot say about the person from whom I heard the occurrence. I did not, it should have been visit the place of occurrence, my lord. The last line, my lord, at page 22, I did not, the place of occurrence, my lord, it should have been, I did not visit the place of occurrence. It should have been visit, my lord. So, my lord, from his evidence, because, my lord, at page 72, your lordship would find the signature of this witness, my lord. Page 72. First signature of this witness, my lord, in the seizure list. And he's a service holder in Orangjuli Tea State, my lord. Kanak Chandra Sharma, my lord. First witness, page 72. Now, PW 9, my lord. He is the other seizure witness, my lord. He is, my lord, Atanu Seal, my lord. And he is a senior welfare officer of Orangjuli Tea State, my lord. And the seizure witness has correctly said that only he and the senior welfare officer were present at the time of seizure, my lord. the PW 8, my lord. He says that only we two were present along with the police at the time of seizure. Hope that the accused has led to the recovery of the alleged weapon, my lord.
Show the down.
Yes, my
It
lord.
was already.
Yes, my lord. Yes, correct. Correct, my lord.
Kept the road.
Yes, my lord. It was there on the road, my lord, and he was only shown. I know both the informant and the accused who was the employee of the Oranguli Tea Estate. The occurrence took place in the year 2019 during winter season. On that time, one line chowkidar Junas Tanti informed me that fire broke out in the house at line number 2. Then I went there. I met the police there. Atwa was residing in that house, though actual owner was Dominic Orang. Atwa Munda was the relative of Dominic Orang, and Dominic Orang allowed him to reside. I noticed one dead body inside the burnt house. The fire was put off. Then police came and started investigation. After 1 hour, Atwa Munda arrived at the place, and on being asked by the police, Atwa admitted before us that he had killed his wife. On being asked by the SDPO Behergaon, accused Atwa Munda admitted that he has killed his wife by giving the blow of dao and left the dao in the place. And he led the police to the place where the dao was left. The dao was left on the roadside in front of the quarter of Kanak Sharma. I also went there. Police recovered the dao and seized the same in my presence. Exhibit 3 is the seizure list. Exhibit 3-2 is my signature as material witness. Exhibit 1 is the dao which was recovered on that day. I could not identify the dao. I went to the place of occurrence at 9 p.m. in the evening, my lord. This is relevant, man. At that time, I found the house was burning. About 1 hour after my arrival, accused arrived at the spot. I met the police. I arrived at the place. Large number of people gathered there before my arrival. I cannot say whether accused was assaulted by Rabin Gwala. The dao was recovered at 1 a.m. Now again there is a discrepancy, my lord. At the time of recovery of dao, I was present along with OC and some other workers. Rabin Gwala was also present at that time, which the PW8 does not corroborate, my lord. I found Rabin Gwala at the place of occurrence. I cannot say whether the dao produced before me was actually recovered on that day or not, but the same size of dao was recovered. I did not notice blood stain on the dao. Police recorded my statement and asked me whether the Atwa Munda was worker of the tea garden or not. Except that nothing was interrogated to me. I did not personally ask the accused. Police was interrogating the accused and he admitted that fact. My signature on the seizure list was obtained in my office. Now your lordship would appreciate his signature was taken at his office, man, not at PO. I cannot remember what was written on the seizure list. So, my lord, the seizure list has to be read over and explained to the persons who are witnessing, my lord. On the same day, police obtained my signature on the seizure list. It is not the fact that accused did not admit anything and he was assaulted by Rabin Gwala and forcefully obtained his confession. I have no personal knowledge about the fact by whom the murder was caused. I did not notice the burn injury on the dead body. The house was burning from backside. Half of the house was burned. The place where the dao was recovered was surrounded by the residents of Kanak Sharma, Malay Chakravarti and Sibu Chakravarti. So, my lord, it was never at the place of occurrence as stated by the earlier witnesses, my lord. PW 2, 3, 4, 5, 6, my lord. Now, my lord, PW 10. He is the inspector of police, my lord.
How many witnesses are there, no?
Altogether 11 witnesses, my lord.
The W10 is the office.
My lord, he only filed the charge sheet, my lord. The investigation was completed by the PW 11, my lord, and he only filed the charge sheet, my lord. Because the case diary was handed over to him and thereafter he prepared the charge sheet, my lord.
Yes.
May I read, my lord?
Yes.
Inspector Mantu Talukdar. On 22/1/2019, I was serving as the OC of Paneri PS. On that day, one Dominic Orang lodged an FIR and I registered it at Paneri PS case number 9 of 2019 under section 302 and 436 IPC. I entrusted the task of investigation to Ibrahim Khalidullah. He conducted the entire investigation, and after completion of the same, he handed over me the case diary. Thereafter, I submitted the charge sheet being CS number 14 dated 25/3/19. Exhibit 4 is the charge sheet. Exhibit 4(1) is my signature. The charge sheet, the CS was submitted against accused Atwa Munda under section 302 and 436 IU. Now, my cross. I have not attached any extract copy of GD entry along with the charge sheet. Now, this GD was later on brought by the investigation officer, my PW11, my lord. Now, my lord, page 26. The last witness, my lord, the sub-inspector who conducted the investigation, my lord, SI Ibrahim Khalilullah. On 22/1/19, when I was working as ASI of police at Paneri police station, on that day at about 3:50 AM, one information was received from Robin Gwala of line number 20, Orangjuli Tea State, in regards to causing of murder of victim Regina Munda by her husband, Atwa Munda. And subsequently, the said house was set on fire. The informant asked the police to take steps. So the OC prepared the GD entry number 442 dated 22/1/19, and I was directed to proceed to the place of occurrence. Then I, along with OC Mantu Talukdar UBC 49, Akhil Vaishya, and one section SSB party, went to the place of occurrence. Then we found the dead body of deceased on the courtyard of the accused. At that time, accused was kept confined by the villagers. My lord, this part is important. I prepared the sketch map of the place and recorded the statement of witnesses. Then I seized one dao and small half-burnt material from the place of occurrence, which were found lying. So, my lord, he says he recovered the alleged weapon of assault from the place of occurrence, my lord. Then, on being handed over to me, I picked up the accused to police station. With the help of Executive Magistrate Kartik Kathar, the inquest was conducted on the dead body. Then the dead body was forwarded to Udalguri Civil Hospital for postmortem examination. After interrogation of the accused was arrested and forwarded him to jail. Then medical report was collected. On the same day, the FIR was lodged by the informant Dominic Orang. Then the OC registered the case being Paneri PS case number 9 of 19 and endorsed the case to me for investigation. Then, after completing the investigation, I submitted the case diary to OC for completing remaining part of investigation. Then OC Montu Talukdar submitted the charge sheet on the basis of the material collected by me. Exhibit 3 is the sizzle. Exhibit 3.3 is my signature. Material Exhibit 1 is the seized dao, which have been identified by me on being produced before the court today. Exhibit 5 is the sketch map. Exhibit 5(1) is my signature. Exhibit 6 is the extract of the GD entry number 442 dated so and so. So, my lord, this GD entry was exhibited by him. Now, cross, my lord. I completed most part of the investigation on the basis of the GD entry. I did not record the statement of OC in regards to the fact that he had initially received the information and prepared the GD entry number. The dao was found lying on the courtyard of the accused. This is very much important, madam. The dao was found lying on the courtyard of the accused. The seizure list was made on 22/1/2019 at about 5:30 AM. Now he says 5:30 AM. My signatures bears the date of 28/2/2019. Now his signature is after a month, my lord, because the seizure was on 28/1/19. The seizure list and the seized materials was made shown by the magistrate on 28/1/19. As per seizure list, the seizure list was shown on 28/2/19 because the signature of the learned CGM bears the date of 28/2/19. Usually the original seizure list is returned back by retaining the photocopy of the seizure list. In the photocopy, also the date of scene is mentioned as 28/2/2019. The seized dhow was not sent for FSL examination, though there was blood stain on the dhow. This is very important, my lord. I did not take any steps for fingerprints examination of the dhow. I did not seize any cloth which was used by victim at the time of occurrence. The sketch map was prepared in respect of GD entry number. The sketch map bears the GD entry number 182 dated 22/1/2019. I conducted the investigation by virtue of GD entry number 442. Now in the sketch map, my lord, the GD entry number is different. And my lord, the GD entry number in the GD entry is 442. These are two varying, my lord. The sketch map bears the GD entry number 182. And he says, I conducted the investigation by virtue of GD entry number 442. It is inadvertently written as GD entry number 182 instead of GD entry number 442. Now the persons who immediately went to the place of occurrence, my lord, after the incident. Now he says, I did not record the statement of witness Shankar driver, Veer Singh Sangha, Junas Tirki, Raju Munda, Zacarias and Jogan, my lord, the person who brought the body from inside the house to the courtyard, my lord. Ravi Sangha, Santi, etc. PW1 did not state before me that the accused has confessed his guilt in presence of village. Witness Atwa Kachwa did not state before me that the accused has confessed his guilt in his presence. Witness Basil Champaya did not state before me that he took out the dhow from the place of where it was hidden by the accused. In the house of accused, only accused and his wife had lived. As per sketch map, the place of occurrence was the courtyard of the accused. The place of occurrence is surrounded by Gango Munda in the eastern side, by Paresram in the western side, Prahlad Gaur in the north, and the road in the south. I did not record the statement of Prahlad Gaur. It is not the fact that I did not investigate the case properly. No prayer was made for recording the confessional statement. Now, my lord, page 30, my lord, the 313 starts, my lord. There was denial, my lord, from his end, my lord. The relevant question is only question number 12, my lord. The reasonable explanation accepted from a husband when his wife has died, my lord, at about 3 AM in the morning, my lord. That explanation, my lord, to be very honest, my lord, is missing, my lord. He speaks about 8 AM to 6 PM, but thereafter he does not speak anything about that, my lord. That, my lord, that should have come from the accused at least, my lord. This is one of the circumstances that goes against, my lord. But however, my lord, 106, my lord, of the Evidence Act is clear on one part, my lord. Even otherwise, if the accused has not placed a plausible and reliable answer to the fact which is within his knowledge, my lord, still then also it is the prosecution which has to prove the case beyond reasonable doubt. by corroborating with all the prosecution witness and their statements, madam. Even if I fail to give a reasonable plausible explanation, madam, under 106, madam, because the prosecution has to lead his own evidence to prove that part. Only after they prove entire aspect with complete chain of circumstances, my lord, then only my reasonable and plausible explanation under 106 is required. If that chain is complete, my lord, if that chain fails, my lord, then, my lord, even if, my lord, I have made no explanation under 106, my lord, then that would not affect my lord. Yes, my lord. I'll refer to that judgment also, my lord. So, my lord, page 33, my lord, the answer of the accused, my lord, to the question, what do you have to say about the entire occurrence? I work as a daily wage earner. On the day of the occurrence, I went for my work at about 8 a.m. I came back from the work at about 6 p.m. in the evening, and I was apprehended by the police at 8 p.m. I do not know who killed my wife, Regina Munda.
That is his explanation. He doesn't know.
But however, my lord, the explanation with regards to the timing of the incident, my lord, where he was during the night until early morning 5, my lord, that reasonable explanation should have come, my lord, to my very understanding, my lord, but which is not there, my lord.
What is this 313? This is a part of 313.
Yes, this is a part of 313, my lord. It starts from page 30, my lord. And, my lord, page 33 is the reasonable explanations. It is sought from an accused, my lord, when it's a case of sorry side, my lord. Because it is presumed that, my lord, in the four walls of a room, my lord, the husband and wife would be present, my lord, generally, my lord. Now, my lord, page 34, the judgment starts, my lord. But the learned additional session judge has written a, my lord, very nice judgment. In fact, my lord, there are contradictions, my lord, which I'll place, but otherwise, my lord, it was very chronologically written, my lord. My lord would first find at page 44, my lord. 44 of the judgment, my lord. The learned trial court, my lord, took consideration of the extrajudicial statement, my lord. In 4 parts, the judgments was given, my lord. Under first was, my lord, extrajudicial confession. Second part, recovery of the weapon. Third is special knowledge of the accused. Fourth is discrepancy of the evidences. Fifth is defect in investigation, and fifth was chain of circumstances, my lord, chronologically. Page 44, my lord.
Nice headings.
Yes, my lord. These headings were taken note of, my lord. Page 44, my lord.
Yes, we got it.
In this case, accused Atwa Munda emerged from a hideout. When public
Page
44.
44, my lord.
Parasite.
Para 17, my lord.
Go ahead.
In this case, the accused Atwa Munda emerged from a hideout when public gathered at his house, and thereafter he confessed his guilt before the public. The learned legal aid counsel for the accused has submitted that the accused confessed before the police or in presence of the police, and the said confession is not admissible in evidence, the same being hit by section 25 and 26 of the Evidence Act. However, a deeper scrutiny of the evidence reveals that the accused arrived at the place of occurrence before the arrival of the police, and he confessed his guilt before his co-villagers present there. It is also possible that the accused might have confessed his guilt again after the arrival of the police person. But that does not mean that the confession made by the other witnesses prior to arrival of the police shall have to be discarded. PW2 Dominic Orang has stated that the accused Atwa Munda confessed before the public and police that he committed the crime. PW4 Paresram Munda has stated that the accused Atwa Munda fled away, but about 5 a.m. when people gathered in the house of the accused came and confessed in presence of PW4 and other villagers that he slit the throat of his wife with kalam katari, an instrument made of iron and used for cutting tea plantation. And thereafter he fled away by setting the house on fire. Then Robin Gwala informed the matter to police.
Even in his cross-examination, the PW4 has stated that the police was not present when the accused came back to the house at around 5 a.m. Police reached the spot 25 minutes after the accused came back to his house. PW5 Atwa Kaswa has stated that the accused fled away after setting his house on fire. At about 5 a.m., he came back to his house and admitted before the public that he killed his wife. PW5 and also heard the accused making the confession. PW6 Basilal has stated that the accused arrived at the place and on being questioned by the villagers, he was brought out the dowel by which he gave the stab injury on the neck of his wife. The accused also confessed his guilt before the public. Then police was also called and the accused was handed over to them. The evidence of PW 2, 4, 5 and 6 clearly shows that accused Atwa Munda came to his house after the public gathered there and then he confessed before them that he killed his wife with a knife. Thereafter, police was called and the accused was handed over to them. Obviously, after arrival of the police, the accused narrated the same confessional story to the police. As stated by PW 4 and 5 in their cross-examination, that police was present when the accused made his confession. The learned legal aid counsel appearing for the accused has also underlined the part of the evidence of PW 9 Atwa seal, where he stated that on being asked by the police, Atwa admitted that he killed his wife. On being asked by SDPO Beargaon, Atwa Munda admitted that he killed his wife by giving a dowel blow and leaving the dowel in a place where he led the police, where the dowel was kept. The mere fact that the accused admitted his guilt before the police, which is not admissible in evidence, cannot wipe out the evidentiary value of the confession which he made before the public before arrival of the police. The evidence of IOPW 11 further clarifies that the accused confessed his guilt before the public before arrival of the police. PW 11 stated in his evidence that when he along with the OC, Manoj Palawkar and the staff went to the place of occurrence, the accused was kept confined by village persons. Obviously, the accused was kept confined by the village because by that time it was revealed that he was responsible for the death of his wife and burning of the house. The accused confessed his guilt before public. This extrajudicial confession of the accused is admissible in advance and can be proved against him. Extrajudicial confession is a weak piece of evidence and the same can be relied upon when it is corroborated by the other evidence. In this context, the following observation of the Honorable Supreme Court in Sahadevan versus State of TN 2012 6 SCC 4 3 are worth money. It is a settled principle of criminal jurisprudence that extrajudicial confession is a weak piece of evidence. Wherever the court, upon due appreciation of the entire prosecution evidence, intends to base a conviction on an extrajudicial confession, it must ensure that the same inspires confidence and is corroborated by prosecution witness evidence. Now, my lord, this part is more relevant. If, however, the extrajudicial confession suffers from material discrepancy or inherent probabilities and does not appear to be cogent as per the prosecution version, it may be difficult for the court to base a confession on such confession. In such circumstances, the court would be fully justified in ruling such evidence out of consideration. So, my lord, my submission in this case is that three of the witnesses have clearly stated that the accused immediately after his arrival was assaulted by the villagers, my lord. So once a person is assaulted, my lord, then, my lord, he will definitely, in order to save himself, he'll definitely make a confession. So, my lord, that confession is not credible in the eye of law, which is under threat and coercion. So this part was never discussed by the learned trial judge, my lord.
Except for the police and the
Yes, my
public.
yes.
Some of the witnesses have stated, mentioned about the presence of police. Some are silent.
Some are silent.
So, learned judge has drawn an inference.
Yes.
That there has been two confession perhaps. One
Before the public and other one before the police. But however, my lord, one part your lordship has to appreciate, my lord. The moment I am before a police custody, my lord, whatever statement I make, my lord, that is not admissible in evidence, my lord. That part is always there. But prior to that, my lord, before the public, I was assaulted, that has come. Because here in this case, nobody is related to me, all are independent. So, my lord, they have stated what they have seen. They have seen me assaulted. So they have said that, yes, he was assaulted. So, my lord, it is not something, it has come from the prosecution side that I was assaulted prior to making of a confession, my lord.
in any case, it has corroboration, then it might.
Yes, yes. Yes, my lord, that part is there, my lord. Now, my lord, second part, my lord, recovery of the weapon. para 23, my lord, page 48. The evidence reveals that the weapon used in the incident thou was recovered from the house of the accused. Though there are some minor discrepancy in the evidence regarding the exact place from which the thou was recovered, the fact remains that the same was recovered from near the place of occurrence and that too immediately after the occurrence. My lord, this part, my lord, the learned trial judge did not appreciate in true perspective, my lord. Because there are two witnesses, my lord, we have to go by the evidence what is there on record, my lord. Now, Kanak Sharma says that it was in front of his house lying on the roadside. And he was shown the thou and he signed on a blank paper. Now, the second witness who was there, he said that I signed the scissor list at my office. So, my lord, from the place of occurrence, it was never seized, my lord. And even the IO says that he has seized from the place of occurrence. And the PW8, sorry, my lord, PW8, my lord, states that the distance between the PO and his house is 2 kilometers, my lord. Scissor list has been prepared and exhibited in this case. Informant of this case, Dominic Orang, PW2, has stated that the accused handed over the dao to the police, which he committed the murder of his wife. Police has seized that dao. In his cross-examination, PW2 had stated that the accused has led the police to the place where he kept the dao hidden. And thereafter, police seized the dao from that place. PW3, Robin Gwala, has stated that the police has seized the dao by the side of the dead body. Now, my lord, PW3, he also said by the side of the body. PW3 was not cross on this statement. The evidence of PW8 that the dao was recovered from the roadside in front of his quarter is not believable. Now, my lord, if the scissor witness, my lord, is not believable, then, my lord, then the recovery of the weapon cannot be, my lord. Because, my lord, the IO had every chances of taking the signatures of the witnesses who were there, my lord, at the place of occurrence.
Correctly recorded that the police had shown him the dao after its removal.
Yes.
And the signature was taken in his spot. This also
Yes.
the evidence.
Yes, my lord, that part is there.
He had not witnessed the actual report.
Since the cross-examination of this witness revealed that he had not witnessed the recovery of the dao. Police has shown him the dao after his recovery and his signature in the scissor list was obtained. So, my lord, what was the point in taking a signature at 2 kilometers far from the place of occurrence, my lord? That was not at all required, my lord.
Anyway, the recovery
Yes.
has not been considered
Yes, my lord.
for conviction. Because
Now-
there's doubt.
Now, my lord, 24, special knowledge of the accused. Now, look, in 106, my lord, my humble submission is that, my lord, I've already made that, my lord, since, my lord, the prosecution has to stand on its own leg, my lord. If the chain of circumstances is complete, then only, my lord, my reasonable explanation on 106 will come, my lord. If that is not there, then, my lord, this 106 will not come, my lord.
Let us see what is 106.
106.
There are many situations in which 106 principle has been applied, where death has taken place inside the house, husband and wife.
And, my lord, the recent judgment on that point is Anish, my lord. Anish judgment, my lord. Anish judgment by 3-bench judge of the, my lord, Supreme Court, my lord. (106), my lord. Burden of proving facts, specially within knowledge. When any fact is specially within the knowledge of any person, the burden of proving that fact is upon him.
You applied this in the present case.
Yes, my lord. This is applied.
Whether burden will be on the accused.
My lord, because in the judgments which have been authored by this court and the Honorable Supreme Court, my lord, what I've seen is that, my lord, if a last seen theory comes, my lord, have I been seen with my wife last by somebody, my lord, then, my lord, this 106 explanation could have been there. Now I have read out from PW 2 to PW 11, my lord. Nobody says that prior that night they saw them together. Even I may be, because these are garden laborers, my lord. These are highly alcoholic people, my lord. And they generally, my lord, after they get their money, my lord, they go out for drinking, man. This is their habits, my lord. That is why what your lordship would find in most of the criminal appeals are of these peoples only, garden peoples, my lord. 95% garden peoples, your lordship would find. So, my lord, this is one. Secondly, my lord, no quarrel prior night, because the house are on lines, my lord, in the gardens. So, lordship, if there was a previous quarrel the other night, my lord, people could have spelled out about that. That about, my lord, previous enmity between husband and wife, that has not come on record, my lord. So, my lord, this presumption of 106, my lord, even otherwise from the evidence, my lord, it cannot be taken out. Only point is that since we are husband and wife, that is the only presumption that we should have stayed in the room together on that night.
Out of IO it came, they used to live together.
No,
Other
my-
witnesses didn't say anything, but the IO said, he saved us, my prosecution. They used
That
to
is
live
correct, my
together.
lord. Even it would be presumed that I will stay with my wife, my lord. It is a natural
No
presumption, my lord.
presumption.
It is always a presumption, my lord. As of enact, my lord.
You were reading the evidence, I think there was a statement to that effect.
Yes.
Only of the IO, my lord. Only of the IO.
One witness is enough.
Only of the IO. But, my lord, natural phenomenon is that the husband will stay with the wife, my lord.
In a
But
situation
as-
like this, in a situation like this, what is actually called for, that death takes place in the
Within the four walls
Probably.
only.
Not, in all probabilities, they were staying together. So, all that the defense or the accused has to do is give an explanation.
Yes.
That explanation.
Correct, my lord. That
Right of
explanation.
that explanation will be another matter. But an explanation, what happened? Then how did the two people were staying in the house and one of them dies. Then how did the death take place? Was there any intruder? Was there somebody else? Something.
But, my lord, other part remains is that these people are otherwise not educated also, my lord. And they don't understand the veracity of their statements, my lord, what they should spell out, my lord. And that apart, my lord, a legal aid counsel was appointed, my lord. So he might not have been properly instructed also, my lord. This point, my lord, I leave it to your lordship, my lord. Now, my lord, page 52, my lord, the trial judge has taken note of the discrepancy in the evidence of the witnesses, my lord. Page 52, para 26, my lord. Page 52, para 26, my lord. In every criminal case, the evidence of eyewitness contains some amount of discrepancy and inconsistency. But that does not mean that the court should discard the entire testimony of the witness. It is the duty of the court to separate the grain from the chaff. In this case, some discrepancies have been noticed in the evidence of witnesses regarding timing when the accused arrived at the place of occurrence. From PW3 stated that the accused emerged only when police came, whereas the evidence of IO PW11 itself reveals that the accused was already confined by the villages when the police personnel reached the place of occurrence. There are some discrepancies regarding the time of occurrence and the place from where the seized weapon was recovered. It has already been discussed above. These discrepancies are minor in nature and do not have the force to destroy the core of the prosecution case. In this regard, the following observation of the Honorable Supreme Court in Brahm Sarup and others versus State of UP in 2000, reported in 2011 6 SC 228 are worth noting. It is a settled legal proposition that while appreciating the evidence of a witness, minor discrepancies on trivial matters which do not affect the core of the prosecution case may not prompt the court to reject the evidence in its entirety. Irrelevant details which do not in any way correlate the credibility of a witness cannot be labeled as omission and contradiction. Difference in some minor details which does not otherwise affect the core of the prosecution case, even if present, could not itself prompt the court to reject the evidence on minor variation and discrepancies. After exercising care and caution and shifting through the evidence to separate truth from untruth, aggression and improvements, the court comes to a conclusion as to whether the residuary evidence is sufficient to convict the accused. Thus, as an undue importance should not be attached to omission, contradiction and discrepancies which do not go to the heart of the matter and shake the basic version of the prosecution witness. As the mental capabilities of a human being cannot be expected to be attuned to absorb all details, minor discrepancies are bound to occur in the statement of witness. It has further been observed by the Honorable Supreme Court in Kameswar Singh and others versus State of BR and others reported in 2018 6 SCC 433 that the maxim falsus in uno, falsus in omnibus, false in one thing, false in everything is not being used in India. Virtually, it is not applicable to Indian scenario. Hence, the said maxim is treated as neither a sound rule of law nor a rule of practice in India. Hardly one comes across a witness whose evidence does not contain a grain of untruth or at any rate aggressions, embroideries or embellishments. It is the duty of the court to scrutinize the evidence carefully and in turn of the fallacious metaphor, separate the grain from the chaff. But it cannot obviously disbelieve this substrain of the prosecution case or the material parts of the evidence and reconstruct a story of its own out of the rest. Efforts should be made to find the truth. This is the very object for which the courts are created. To search it out, the court has to disperse the suspicious cloud and dust out of the smear of dust. All of these things clog the very truth. So long as the chaff, cloud and dust remains, the criminals are clothed with the protective layer to receive the benefit of doubt. So it is a solemn duty of the court not to merely conclude and leave the case the moment suspicions are created. It is the onerous duty of the court within permissible limit to find out the truth. Now, my lord, as far as defect in investigation is stated, my lord, the court has otherwise taken that these are minor lapses on the part of the investigation, so this should not be taken so much of, and that is very correct also, my lord. This I am not disputing. Now, for this chain of circumstances, my lord, the law engrafted in Sarat Bichan Sarda was taken, my lord. The chain of circumstances, my lord. The 5 golden principles, my lord, these are taken care of.
Sexual part no. First thing. Yeah,
My lords,
Yes.
I have a small way to make, my lord. Since I took this paper book only on Saturday, my lord, because the earlier counsel was an amicus, my lord, he expired, so the case was given to me, my lord. Only for placing the judgments, my lord. Can it be day after tomorrow, my lord? Only for placing the judgments, my lord. I'll conclude, my lord, within 15 minutes or 10 minutes, my lord, on that day, my lord, if lordship permits. Yes, some decisions I brought, my lord, some decisions I brought, my lord.
J. Das was there. J. Das was there.
Yes, my lord.
Earlier.
Yes.
Earlier,
that's what-
Jasasi Dal was there, my lord. He expired, my lord. So, my lord, this was given to me.
Yes, there's no problem. You can produce your decisions you want to rely upon.
Yes, my lord.
So trial court has summed up
Yes, my lord.
page 38, paragraph 38.
38, my lord.
Sentence has been
Life imprisonment and 10 years on 436, my lord.
concurrent.
Yes, concurrent, my lord. We will run concurrent, my lord.
Yes.
I would also like to do my part on Thursday. Why, your lordship? 106 burden, the accused has to explain it, my lord, which he has failed to do so. But as regards extrajudicial confession, I want to minutely see whether it was done in presence of the police. So if it is done, most of the witnesses were broken, your lordship, that they say that it was done in presence of police. So it will go. If I can find out at least one, your lordship, that would come in my favor, in the favor of the prosecution. And
Presence of police.
yes, so
but
that will go, your lordship.
Other aspect is also after the public had thrashed him.
Yes, whether public and police, they were at the same time they were there.
No, even if police had not arrived,
Yes.
but the confession was based on the public having beaten him.
So,
Then
your lordship,
what would be the result?
no. So if I can find out at least one witness who says, your lordship, whether he was present when like time of occurrence, my lord, whether maybe some variation. Maybe when it was given to him, public, he was not beaten up. One of the witnesses has said. And at that time, if the police was not there, then it would be admissible. There was no coercion.
Some of the witnesses are silent about the.
Yes.
Just one or two. of them.
Yes.
Some others have stated.
So, lordship, PW5 goes, I think it goes. Confession made before him. Then PW6 probably would go. Then PW9 probably would go, your lordship. If I can find out at least one, my lord. Day after tomorrow, my lord, it's a hardened part hard maybe. Thursday. An accused fled away from the scene. That is one of the circumstances.
Yes, summed up the setup.
Yes.
Please write down. Hardened part, this matter again on 12/2/2026 as part of.
Lordship.
I'm deeply
Like-
obliged, your lordship. I'm deeply obliged.
I'm sorry, 30.
This is an appeal against conviction of 302.
Lordship, here we need some accommodation because my lord, here we don't have the paperwork. Somehow maybe it was misplaced, my lord. I received a copy from my learned friend today. We need some time to go.
Many witnesses.
Can it be fixed on 24th or 25th of this month? 24, 25, 26, whichever day is lordship available.
It can be fixed.
42 court witnesses.
24.
24. It's of competition.
Learned additional public prosecutor suffers that he had misplaced the paper book and he has secured a photocopy of the same from the opposite party. He therefore submits that he requires some time to prepare the matter. As a on list again of list on 24th of February 2020.
Obliged.
For hearing.
Sixteen and 17. And
Lordship, it's a both matter are taken together, Lordship, arising out of the same judgment, Your Lordship. Our service is not there, Your Lordship.
You are there in both the case.
No, Lordship, I'm only in 16, Your Lordship. Yes, Lordship, 16. Today we
Then
have,
item 16.
yes, Lordship. Rafiq Ali.
It's arises out of the common judgment.
Yes, Lordship.
And both these appellants are the
Yes, Lordship.
accused, co-accused.
Co-accused, Lordship.
Rafiq Ali is jailed.
Lordship. So matter will be heard together, Your Lordship.
You are there for item
16, Your Lordship, 16.
Who is there for 17?
Z Commerce, our senior counsel, Your Lordship, probably.
Not available?
He is not available, Your Lordship.
You're for 17.
No, no, I'm only for 16, Your Lordship.
So PJ Manta is there?
Lordship, and probably the last week of March, then will be free.
Conviction is under
302, Your for
302.
302 for life, Your Lordship.
And judgment was passed on which date?
Lordship,
Date of judgment?
date of judgment,
2024.
probably.
7/3/24.
Lordship.
CP, what do you say?
Lordship, both the learned senior counsel are not available now. Jet Commander TJ.
Lordship.
These for item 16.
16.
So who will be the lead counsel? Mr. Manta?
Lordship. He's also have some difficulties today, Your Lordship. He was there, Your Lordship, but
Is right. Difficulty has been expressed on behalf of the learned senior counsels appearing for the appellants in these two matters. Stop as prayed for and not objected to by the learned additional people. These matters for hearing.
last week,
March.
31st.
Give a date.
No, that will be difficult, Your Lordship. 31st, that will be better, Your Lordship.
31st of March.
Lordship. Habla.
Please, Your Lordship.
Yes.
This is a matrimonial matter. So this maybe go for mediation.
Learned counsels appearing for the rival parties submit that the matter may be referred for mediation. Stop. It is seen that the matter pertains to a matrimonial dispute and mediation 2.0 has been launched recently. So accordingly, let this matter be placed before the mediation center for mediation expeditiously. With due intimation to the parties concerned.
Much obliged, Your Lordship.
Number 17, my lord, I was ready.
Sorry,
Item number 17, my lord.
17.
It is tagged with 16, but I was ready in 17, my lord.
We were adjourned it to 31-3. Who will be appearing? Z Kamar or yourself?
I will appear, my lord.
You will be appearing.
My lord. Can it be in this month, my lord?
Council has left. No, sir. Oh, you are the one.
No, I'll do so.
You want to? When do you want it?
My lord,
First week, second week, March?
26, my lord.
26.
Then in that case, my lord, 117, my lord. 17, my lord, I will be ready. Today also I am ready, my lord, in fact.
But they are not ready.
My lord, he will be not available from 23, my lord. He will not be available from 23. 17, he will be there, my lord.
17 will be there, sir. So you change the date as 17.
March.
My lord. No, my lord, February.
Oh, February.
My lord. It is not, it's February. Next week, my lord.
Lordship, may I
Next
take an instruction from my senior? He is not available, that's why.
My lord, his senior is not available from, my lord, 23rd of February.
Before that, he is available.
My lord. That is why, my lord, I was
Let me have the instruction.
on 17 if it is possible.
All right. Find out. Change the date accordingly.
Item 19.
My lord, in this matter, my lord, a DNA profiling test was directed, my lord. That was conducted. The report is in the records, my lord.
What was conducted?
A DNA profile test.
DNA profile.
Yes.
In terms of which order?
Order date is 16/9/2025. The previous order, my lord, will clarify. My lord, sees the order, my lord, 21/1/2026. 21/1/2026.
Additional evidence was directed to the.
I'm sorry.
Additional evidence was directed to the.
My lord, DNA, it is there in the records, my lord.
Doesn't it?
21. Report has been received, my lord. If my lord sees the 21/1/2026 order, my lord.
Man.
See,
The report did not match with the profile of the appellant.
okay, thing is that you see, the regular, this is not a regular bench. Regular bench has passed an elaborate order.
Mine.
So a detailed hearing may not be required in such a situation if it is taken up by that bench.
Right.
Perhaps we have it next week.
Next week.
Next
You all agree? We'll give you a date.
Can it be on Monday or Tuesday, my lord?
No, let it be on
Thursday will be. better.
19th, Thursday. There'll be appropriate.
There was a DNA was taken and then additional evidence was taken and report was sent.
Yes.
Yes.
Please write down, list this matter on 19th of February 2026 by the parties.
My lord has fixed it on when?
They're fixed it on 19th.
19th of.
Thursday, the hearing date.
For this bench, my lord, every day is a hearing day.
Correct. There's always a hearing matters out there.
Yes.
But at best, I think more than 2 hearings is not possible.
Yes, madam.
This will not require much time.
Especially, generally speaking, generally, when the conviction is of 20 years and more and in POCSO and life
Right.
imprisonment in case of 302 and all that. So we have to go through each and every part of the.
But
evidence.
I
It will not
understand.
be fair. We will not simply just go through and say when dismissed or allowed or whatever. So we have to be meticulous.
On 19th, my lord. I'm deeply obliged. Much.
That is 16, 17, my lord, his senior will be available on 17th, my lord.
On 17th.
My lord. Next Tuesday, my lord. He'll be available with that.
All right.
My lord.
You tell the lady who was gone. Slip back. Rakhi. Date has to be changed from 31st March to change to 17/2 instead. 17th February is informed.
Obliged, my lord.